But I pay for listing of one IA on 9th million.
What is the IA about?
IA is for suspension of sentence and bail million. Much.
Part 2, Harvard method, item 99.
May please, your lordship. I made a small note for your lordship's perusal. Of course, I could make it in one page. One accused includes 2 pages and one accused involves 1 page. There are circumstances that I could call out.
1 minute.
Lordship.
Let us go through the note.
Lordship.
Mr. Mahajan, take your seat. We'll just quickly go through the note.
Lordship.
Likely type to is polyamorous. But also, Magdalene,
All right, now, first of all, we appreciate within a short time you have come up with this. You've put in some effort. But please tell us one thing. You crave leave of the court to refer to 161.
161, because Lordship had seen all are contradicted.
Mhm.
If at all I can say PW3, it's an omission because he did not say it to the police and police that contradiction is not true. He simply said, I had not stated to the police about these statements, and it was not contradicted, it was not placed before the IO. So at best, I can say it was an omission. But 4 and 10, there is clear contradiction. But I've seen 161 statements. There are statements against him.
Against
So
who?
for
Against
against the accused,
Which
Deepak and Dipul,
both.
by both. I'll just refer to it once, Lordship.
All right. So you have completed your arguments yesterday?
Well, I have to place some judgments on you.
Acha. Okay, then let him place the
Not-
judgments. Yes.
Well, given one.
Yes, yes, it is there.
I won't refer everything, my lord, only 1994 supplementary to SCC 327, my lord. Arjun Marik for the state of Bihar.
Yes.
Para 31, my lord.
Yes.
Thus, the evidence that the applicant had gone to Sitaram in the evening of 19 so and so and had stayed in the night at the house of the deceased Sitaram is very shaky and inconclusive. Even if it is accepted that they were there, it would be at best amount to be the evidence of the appellants having been seen last together with the deceased. But it is settled law that the only circumstance of last scene will not complete the chain of circumstances to record the finding that it is consistent only with the hypothesis of guilt of the accused, and therefore no conviction on that basis alone can be founded. On the same line, my lord. This is a 2022 SCC online SC 1511. S. Kaliswaran versus Inspector of Police Pollachi.
Yes.
A pair 13 minutes. The failure of the accused in the case based on circumstantial evidence, which included last seen together theory to explain under section 313 as to under what circumstance the victim suffered death, would also not be a ground to arrive at an irresistible conclusion that the accused were involved in the commission of the alleged crime. In the instant case, even if the theory of last seen together propounded by the prosecution is accepted, then also it is difficult to draw an irresistible conclusion that the accused are guilty of the alleged offences merely because they fail to explain as to under what circumstances the victim suffered death.
Yes. Yeah, but you see, these are all decisions rendered in the facts of each
That's
case.
of the case, my lord.
Hmm.
And these two are for default, my lord. For default, I would say there is no
So
any
that,
last scene,
that you have already
my
argued,
lord. And
that
then,
we'll consider.
my lord, and then, my lord, the third one, my lord, Lordship would appreciate, my lord, PW 5 had already lodged a GD entry on 30th that night, my lord.
Hmm.
And on that basis, the investigation is started, my lord.
Hmm.
The FIR before the prosecution FIR, my lord,
Hmm.
then becomes a 161 statement, my lord, because it is during the course of investigation, my lord. And that 161 can be at best be used to contradict the informant, my lord. Butaram does PW 3, my lord. And that has been done, my lord. This judgment, my lord, 2014, 4 SCC 747, my lord. Ashok Dev Burma by State of Tripura.
Yes.
The para 15, my lord.
Hmm.
Para 15, my lord. Seventh line from the bottom, my lord.
Hmm.
Unless from a though the complaint. My lord is symbol. Though the complaint received from PW2 was treated as the first information report, the fact remains that even before that, PW18 had started investigation. Consequently, written as information Exhibit 1 received from PW2 at best could be a statement of PW2 made in writing to the police during the course of investigation. Of course, it can be treated as a statement of PW2 recorded under Section 161 CRPC, and the contents thereof could be used not as the first information report, but for the purpose of contradicting PW2.
Hmm. Yes.
The PW2 he was duly confronted with the FIR, my lord, and he has admitted that he has not stated this and this in the FIR, my lord.
Hmm.
The Ganesh Jogo is on the same lines, my lord. Then in para 16 and 17, my lord. And then, my lord, finally, my lord, 2013 SEC online GAU 410, my lord.
No, no, what are you relying on, Ganesh Gogoi?
The same as
Oh.
Debbama, my lord,
Huh?
same as the 2014, my lord.
Let us see.
Para 16, my lord. PW7 Prabhat Gogoi is another police officer. He initially took up the investigation and he recorded the statements of witnesses, but they have not been examined in court. He claimed to have filed the FIR. In cross-examination, PW7 reports that in the FIR, he has not specifically mentioned the involvement of the appellant in the FOC incident. He did not mention anything about the statement of the witness, Sushil Mazumdar. The FIR recorded by PW7 in this case during investigation. However, in the course of his evidence, PW7 never stated anything about the appellant being a member of the United Liberation Front of Assam. In the FIR, it has clearly been stated that investigation has already been taken up by me. Certified copy of GDA number so and so is enclosed herewith. It is clear from the FOC statement, investigation in the case had already commenced. And once investigation commences, the FIR is hit by Section 162 CRPC and no value can be attached to the same. Other than that, for contradicting the informant matter.
Yes.
Here, my lord, PW 9, my lord, the IO, my lord, in his chief, my lord, clearly states that PW 5 had come sometime on 30th, my lord, that intervening night, my lord, lodged a GD entry, bearing number so and so. And on the basis of that GD entry, he had commenced investigation. He had visited the place of occurrence and he had seen the witnesses, my lord, but nothing had been found. Afterwards, PW3 had lodged an FIR, and then he again went, and upon when the witnesses showed him the body, my lord, he found the dead body. But investigation already commenced, my lord. And then, my lord, 2013 SCC online GAU 410, my lord. There are 26 minutes. Opposite Nandi or Siddha Assembly.
Hmm.
In the case at hand, when there is no evidence to show that it was the accused appellant who had injured so and so, and when the possibility of the other inmates of the house, aforementioned, having committed the offense, could not have been boldly ruled out, the present appellant, Abhijit Nandi, would not have been convicted, particularly when the remaining accused were acquitted by the learned trial court by, according to them, benefit of doubt. At any rate, the present appellant in the case at hand deserved to be accorded benefit of reasonable doubt.
These are all on the facts of these cases. If the evidence is not there or the charge is not proved, then benefit of doubt has to be given. You can have 5,000 judgments on that. Why are you relying on these judgments?
Well, because
In that case, the court held that there was no evidence.
Well,
So he should have been given benefit of doubt as the others. That's the settled law.
well, I'm
Yes.
relying on this because people possibly, my lord, similarly placed with the other accused.
That's right. If the evidence against Dipul is the same as the other accused persons who have been acquitted,
My lord,
then he will be acquitted.
my lord,
There's no need to argue on that.
my lord.
If there is a different piece of evidence against him, which is over and above what is available against others, then we will examine what is the probative value of that evidence. And if we find that it doesn't bear out anything, then he will be acquitted. If we find that no, this evidence is different and has an impact on the case, then we'll consider it.
Gotcha.
But your case is that even if one can say there is some evidence, it is against only Deepak Das, appellant Deepak.
That taking him away, my lord, and
And that
rebuking the
evidence is that he was seen to have been taking away the victim
rebuking.
and he was rebuking him. So these two circumstances viewed in the light of other materials at all, if at all, can be seen as incriminating, but there is nothing else against the others. That's
Right.
your argument? Anything else?
And my lord, the prosecution has let no evidence as regards 34, my lord, that there was a prior concert of minds.
That's right. That we have yesterday mentioned. Hmm.
Pleasure.
Logic. In fact, the point that my learned friend has urged that the GD entry will be the FIR. There I agree with him because there are decisions Lordship knows if after the GD entry, the investigation progresses to certain extent, like statement of witnesses are taken,
Investigation commences.
commences, or to some extent it goes, then it will be an FIR. FIR will be hit by 162. Here I've seen the case diary after GD entry, the entire process went on. They were seized, statements were recorded, they went 7:45, the police reaches the place, 7:45, police reaches the place of occurrence in the morning when the body was recovered. After the body was recovered, the villagers again informed. Initially, police were informed, they did not come twice. Thereafter, when the body was recovered, police was informed, police came to the place of occurrence at 7:45, and then the entire investigation starts. And at night, 9:30, the FIR comes into place. So as far as this particular argument is concerned, that it was hit, there I'm agreeable, is DD will be the first information. Now, as far as circumstances are concerned, Lordship has already seen, the first circumstances is taking him away. PW 1 and 2 both said that they were talking to the victim, and then Deepak Das comes in his bike, and then he threatens the witnesses, whoever was talking, 1, 2, everyone, and then he took him away. So as far as that circumstance, and took him away to his house. PW 2 said Deepak had taken Hemant, he made him sit in the motorbike, and he takes his towards his place. So Hemant was taken by Deepak to his place. If your Lordship wants to see that to his place, Lordship can see that statement of PW2. PW2 had stated. PW2.
Seven.
PW2. He said page 11 is the
Yes, let us read PW2.
PW2, page 11 of the paper book. He said at about 7:30 PM, when I, along with Bikash Das, returning from the marriage ceremony performing near the house of the accused, then near the culvert, we met Hemant Das. While we proceeding near the culvert, Deepak Das came on a bike and he threatened us. Then we left the place of occurrence and Deepak Das took Hemant Das along with him towards his residence. So taking him from the culvert to the residence of Deepak Das is there in the statement of PW2, corroborated by statement of PW1. PW2 corroborating statement can also be found in 164 statement of PW2. Lordship for a second can go to the 164 statement of PW2. Monjil Das.
Yes.
This is at page 112.
Yes.
112, Lordship will see here. Again, the same facts. Marriage ceremony was going on, taking along my nephew. When Bikash Das and I were returning from there, we met Hemant. He called me and I too called him, and three of us were talking for a while. In the meantime, Deepak Das riding a motorcycle, did Lordship get? Yes. Riding a motorcycle reached near us, and then he stopped his motorcycle. He abused Bikash and me by calling us dogs and made both of us to stand by holding our ears. Thereafter, he pulled Hemant from among us and took Hemant along with him. Out of fear, Vikas and I went to our house. I don't know where Deepak took Hemant thereafter. Here, of course, he said, I don't know where he took thereafter. After that, Hemant's mother approached me. As far as taking away, there is corroborating statement. To his residence, of course, is only before the trial court.
Yes.
As far as taking him to his residence, there are enough evidence. Thereafter, the second circumstance would be PW3 statement, Uttaram, the informants.
1 minute.
Lordship.
মানা কৰিছিলো আনিবলৈ। Yes.
PW3 in his statement before the trial court said that he went twice to the place of the accused. First, he went when Fultara informed, PW10 informed. He went to the place of the deceased, accused, and he saw accused assaulting the deceased. He said, page number 13, I'll point out only those relevant parts. Fultara informed me. I proceeded to the residence of Deepak and saw that accused persons were assaulting. Accused persons, in fact, this includes all, even Dipul. I saw that accused persons were assaulting Hemant and I saw the incident in the electric light. Robin and Batahi chased me. Then he left the place. First instance, he goes and he saw them assaulting. Then after half an hour, he came back. After half an hour, I, along with some neighbors, went to the residence of accused persons. When we went there, there was no light. And on being asked, Deepak Das said that they have freed Hemant. So he went twice to the place of occurrence.
What is the meaning of freed here?
Yes, this
Freed
shows
means-
he was there. Hemant was there and we had freed him. He is no longer there. This will have many interpretation that Hemant was there. He admitted. And we freed him. So these statements are there in PW3's deposition. Now, there is contradiction. PW3 in his statement, during his cross-examination, the later part, Lordship will not do these talks of motive and all. Then the contradictory part, or at all, I won't say contradiction, it's an omission in my humble submission. First of all, FIR was confronted to him and he said that I have not stated so and so in the FIR. FIR is not a substantive piece.
He
This
is the informant.
is the informant.
PW3 is the informant.
Yes. PW3 is the informant.
Yes, where does it say? I have not said so in the FIR.
Page number 15. Page number 15, Lordship will, leave 3-4 lines from the top, then Lordship will find. Next day evening, I filed FIR. I have not mentioned in the FIR that Full Tara informed me. And then I went to residence of accused and saw that accused were assaulted. I have not mentioned in the FIR that we went to residence of Deepak told, and then Deepak told that they freed Hemant. I have not mentioned in the FIR, prior filing of FIR, twice I went to the police station, but police did not respond to my oral information. I have not stated before police during investigation, this is 161, that after giving information by Full Tara, I went to the residence of accused and thereafter again at 10 p.m. I went to the residence of the accused because police did not ask me about this. In fact, here FIR is also in 161, so these are all contradictions. And he said the reason he said police did not ask me. And let us go to the IO statement. IO, Lordship will find that page number, IO is PW9.
Nine.
And Lordship will find it at page, the relevant part is page 26.
Yes.
Page number 26 down below during the cross-examination. This PW3 statement is not confronted. Defense did not put it to the IO. The contradiction was only in respect of 1 and 4. And 10 later. So contradiction, Lordship knows, is not proved here. Proved will be, he said, I have not stated here. It is proved that I did not state. But he said, police did not ask me. And I have checked his 161 statement. I can read it out. It's a very short statement. He, of course, did not say. Lordship, I'll just read out. Mur namo thikana so and so. Oh, this is a typed one here. Mur namo thikana so and so. Diamote hoy juakali iman tarikhe budbare rati onuman 8 মান বজাত গাঁৱৰে শ্ৰী মনা দাসৰ দোকানৰ সন্মুখত শ্ৰী মঞ্জিল দাস আৰু বিকাশ দাসৰ লগত মোৰ ভাই হেমেন দাস থিয় হৈ থকাত এজাহাৰত উল্লেখিত 1 নম্বৰ পদকীয়াই তেওঁলোকৰ ঘৰলৈ বলপূৰ্বক ভাৱে টানি নি আটাইকেইজন পদকীয়াই অমানিক ভাৱে কি অমানিক অমানিক ভাৱে মাৰপিট কৰি হত্যা কৰি সাক্ষী প্ৰমাণ নোহোৱা কৰাৰ বাবে ঘিলা জাৰি থকা পুখুৰী এটাৰ পানীত পেলাই থয় আমি বিচাৰ কুচাৰ কৰি আজি ৰাতিপুৱা মৃতদেহটো পুখুৰীৰ পৰি থকা দেখি লগে লগে হালমাৰা আৰক্ষী চকীত খবৰ দিওঁ আৰু মই অপৰাধীগণক কাৰ্যত কৰি বিহিত ব্যৱস্থাৰ কাৰণে চকীত এজাহাৰ দাখিল কৰোঁ. He simply said they had taken him, assaulted him and the body in the pond. He did not say, I went there on being informed by Fultara. I saw them assaulting. I was chased. Thereafter, again, after half an hour, I went. And then Deepak said, we had freed. That part is not there in 161. And he said, police did not ask me, I did not say. So, in my humble submission, of course, subject to your lordship's opinion, that will not be a contradiction in the fact of this particular case. That can be an omission. He said, I have not stated. So that is the second circumstance that I can rely on. The third one, body was found in the morning in the fishery of one Kalyan Das. Then coming to PW4. PW4 is the daughter of Fultara.
Acha, we missed out
Daughter-in-law.
PW1 in the beginning. Why
Ah.
don't we just have a look at PW1?
PW1. Bikash.
Hmm.
Similar statement was made. Manjil and I myself went to the residence where marriage ceremony was going on. Then after returning from the residence where marriage ceremony was taking place, we found Hemen Das was sitting near a culvert. Then we talked to Hemen and accused Deepak Das came to that village on a bike. Then Deepak Das threatened all of us and took Hemen Das with him. Then we came to our residence and slept. After some time, mother of Hemen came to our residence and asked about him. Then I replied, Hemen was taken by accused Deepak Das. Next morning, we heard that dead body of Hemen Das was lying in the pond of Kalyan Das. Police recorded my statement. Police took us along with the dead body. Deepak Das took Hemen Das towards the western side of the culvert. After bringing the nephew Manzil, we sit on the culvert. At the time, the said place was dark. Accused Deepak Das rebuked us. After we went from the culvert to my residence, it will take around 15-20 minutes. Deepak Das stands bike near the culvert and walked along with the deceased. I have not stated the above facts before police, as police did not ask me the said question. As we sitting at culvert, as such, Deepak Das kneel down us near. It is not a fact that I have not stated before police that mother of Hemen Das came and asked me about Hemen Das and that I told her that Deepak Das took him. It is not a fact that I have not stated before police that Deepak Das took towards the western side. And it is, of course, there is again contradiction. This PW1, it is in the police's statement. He did not state before me that mother came to him and asked about Hemen Das. That contradiction is there. And I think in someone's statement, it is said that the accused house was on the western side of the culvert and the deceased house was on the eastern side, the opposite direction. So the accused had taken Hemen Das towards the western side of the culvert. This shows he was taken towards his place. And PW2 is clear towards his house. PW2, there is no contradiction. PW1 and 2 taking him, there is no contradiction as such. PW3, there can be an omission.
Yes, you wanted to read PW4?
4.
Yes.
Now,
please.
4 said that in her statement, she said that when one lady Poddar informed her, she went to the place of occurrence and there she saw Deepak Das taking the deceased towards the backside of his house. Lordship can see her statement, page number 16.
Yes.
One lady Poddar informed me that Hemen Das was taken by Deepak Das and accordingly I went near the residence of Deepak Das. I was skipping under the bamboo bushes. I saw that Dipul Das tied Hemen Das along with a mango tree and assaulted him. After a while, Deepak Das came and took him to the backside of his residence and I heard some sound, but did not see what happened inside his complex. Next day morning, we found the dead body of Hemendas in the fishery of Kalyan. Now her statement before the IO was placed before her, and she said she refused that she had not stated. She denied that she had stated before the police. Now page number 17. It is not a fact that I have not stated before the police during investigation that Dipul Das tied Hemen along with a mango tree. Then it is not a fact that I have not stated before police during investigation that after a while Deepak Das came and took Hemen to the backside of the residence and tied along with a tree. Lordship will go to IO statement then.
iOS 30.
By IO is page 13. IO is page, no. IO is page 26.
Page 26.
Page 26.
Hmm.
PW4, the last paragraph of the page. PW4, Moromi Das did not state before me that accused Dipul Das tied Hemen with a mango tree and assaulted. Then again, PW4 did not state to me that after a while Deepak came and took Hemen to the backside of his residence and tied him with a tree. So there is a contradiction, as has been pointed out by the IO. So I would like to place the 161 statement once. Yesterday I read it, but I just wanted to read it again because it's a little long, one page. Moromi Das, her 161 was recorded on 1/5 next day, before the FIR was lodged. After GD entry, her statement was recorded. Mur namo thikana so and so. Moi heri hakhi ho, gusora hakhi ho. Jua so and so tarikhe rati iman man bojat Hemen Dasor Deepak Dase Hemen Dasok Deepak Dase tar ঘৰলৈ টানি নিয়া খবৰ পাই মই মোৰ স্বামীৰ ঘৰত লগত দীপকৰ পুখুৰীৰ পাৰত চুপি থাকো পুখুৰীৰ পাৰত she said here she said bushes হেমেন দাসক হত উপযুক্ত প্ৰকৃতিৰ মানুহ ইহঁতৰ ঘৰলে নিয়ে যিয়ে যায় তাকেই মাৰধৰ কৰে. What she's saying is that they are little antisocial. Whoever goes gets beaten up. মাৰধৰ কৰা স্বভাৱ সিহঁতৰ আগৰ পৰা আছে. আমাৰ সুবাৰ প্ৰায়বোৰ ল'ৰা সিহঁতৰ হাতত মাৰ খোৱা হয়. হেমেন দাসৰ হেমেন আমাৰ মামা হয়. মোৰ মা শ্ৰীমতী ফুলতাৰা দাসে হেমেনক বিচাৰি দীপকক হতৰ ঘৰত সোমোৱাৰ লগে লগে দীপক দীপুল ৰবেন আদিয়ে মামা হেমেনৰ ঘৰৰ পিছফালে নি হত্যা কৰি হেমেনৰ মৃতদেহটো টানি পথাৰলৈ লৈ যায়. But she's simply saying that উক্ত ঘটনা মই আৰু মোৰ স্বামী শ্ৰী মিন্টু দাসে নিজ চকুৰে দেখা পাওঁ.
So according to 161, she is a eyewitness.
Yes. No, here also she said, oh yes, she said he had taken to the backside of his house and heard some sounds. Here she said, Mur ma Srimoti Fultara loge loge Deepak Dipul Robin Adie Mama Hemenor ঘৰৰ পিছফালে নি হত্যা কৰি হেমেনৰ মৃতদেহটো টানি পথাৰলৈ লৈ যায়. উক্ত ঘটনা মই আৰু মোৰ স্বামীয়ে মিন্টু দাসে নিজ চকুৰে দেখা পাওঁ. This is little more than what she stated before the trial court. তেতিয়া আমি দীপকৰ ঘৰলৈ যাব খোজোতে দীপকে আমাক দা লৈ খেদে. আমি ভয়তে তাৰ পৰা গুচি আহো আৰু গাঁৱত যাক লগ পাওঁ তাকে ঘটনাটো জনাও. গাঁৱৰ প্ৰায়বোৰ মানুহে সিহঁতক ভয় কৰে. গতিকে কোনো সিহঁতৰ ঘৰলৈ যাব সাহস নকৰি হেমেনক বিচাৰি পথাৰৰ ফালে যায়. ৰাতি হেমেনক পথাৰত বিচাৰি নাপায়. ৰাতিপুৱা ভাগত গাঁৱৰ পিছফালে থকা পুখুৰী এটাত হেমেনৰ মৃতদেহ উদ্ধাৰ হয় আৰু উত্তেজিত ৰাইজে হেমেনৰ ঘৰৰ ফালে হেলে আৰু থানাত খবৰ দিয়ে। Here she said, I had seen. But one statement is the same, that she had stated that he was taken towards the backside of the house. And thereafter he was killed and then taken to the Pukhuri. That is, of course, more than what she said. But the contradiction that the police stated, that she had not, Moromi did not state before me that Dipul Das tied. Of course, this is there. Dipul Das tying in the mango tree, she did not say. But the other statement, PW4 did not state to me that while Deepak came and took Hemen to the backside of his residence and tied him with a tree. Tied him with a tree is not there. Only taking towards the backside of the house is there. That contradiction is not there. That she had stated. লগে লগে মামা হেমেনৰ ঘৰৰ পিছফালে নি হত্যা কৰে। That a statement of PW4 is not contradicted to the extent as has been projected. Hostile try to be see. He was almost an eyewitness. So here I rest with PW4. Contradiction as projected is not proved. But going by your lordship judgments and the earlier Supreme Court, proving the contradiction is the way it is being done here. It was placed, she said, I have not stated. It was placed before the police. Police said she did not state. But for the ends of justice, I'm placing this 161 statement. Sometimes police are not believable. Then coming to PW10, there is contradiction in her statement also. PW10, Pultara, she said in her statement before the trial court that when she was on her way to a shop to purchase something, she saw appellant number 1 dragging the victim to his house. And when she followed, she was chased. This is what her statement. Lordship will go to PW10 statement once, page number 28. There are two parts in her statement. First, she said, I saw dragging. Second, she said, I saw assaulting. Lordship will skip 5-6 lines from the top. Shop belonged to one Sana Das. Thereafter, at that time, I noticed Deepak Das was dragging deceased Hemen and took him to their residence. I followed them up to their courtyard, and seeing me, accused Deepak and Dipul tried to assault me and they chased me. I came to my house. So the first part, when she heard and when she went to his place, he saw appellant number 1 dragging Hemen towards his residence. And then she saw Deepak and Dipul tried, seeing me, Deepak and Dipul assaulted me and they chased me. Dragging part. Second statement, there is a further statement. Lordship will again leave her. Thereafter, she came back home. Thereafter, she went and informed Bhutta Das. This is again a corroborative statement. Bhutta Das said that PW10 informed. She said, I informed Bhutta Das. Thereafter, Bhutta Das went to the house of the accused person. I did not visit. Thereafter, Lordship will see. I noticed that Hemen was assaulted by Dipul Das, Deepak Das, Batehi by tying the deceased in a tree by rope. This is again a second part. She also saw the assault. This is, Lordship will see the statement that was placed before her, the statement recorded by the IO. In her cross-examination, Lordship will leave 4 lines from the top. It is not a fact. She denied of not stating. It is not a fact that I did not state before police that on the day of occurrence, I went to the shop to purchase edible oil. Then I noticed Deepak Das dragging to the house. Then I followed. I noticed Hemen was assaulted by accused person and they tried to assault me and chase me. It is not a fact that in my statement before police, I stated that 8:30 I heard that Hemen was dragged by so-and-so. Hearing part she denied. She said it's not a fact that I have not stated. Then police, Lordship will go to the contradiction that was proved by placing it before the police at page 27. Lordship knows. Fultara, police have stated, witness Fultara during her statement at 161 did not disclose before me that on the day of occurrence she went to the shop, then noticed Deepak Das dragging Hemen. She followed him and then she was chased, and that all the accused had tried to assault her, and that deceased Hemen was assaulted by the accused person, police have stated. Now the contradiction seems to be proved. Now if I place before the 161, not a very long one, no, it's 2 pages, I'll just read first. Then at so-and-so Rati, Homoy Onuman Titia Hat Sarehat Hosil, Amar Gaur Hemenok, Hemendasok, Hemenok, Deepake Bator Para Tani Loi Juar Hobortu Puar Loge Loge, Moor Bor Boy Lagisil, Karon Deepakor Boni Lobitar Logot Hemenor, Jua 5-6 বছৰৰ পৰা ভালপোৱা চলি আছে যদিও দীপক আৰু দীপুলে এই
যদিও লবিটাৰ ককায়েকে দীপক আৰু
যদিও
লবিটাৰ ককায়েক দীপক আৰু দীপুলে
দীপক আৰু দীপুলে এই কাৰ্যত
সম্পূৰ্ণ
বিৰোধী they are against that relationship দীপক আৰু দীপুল গাঁৱৰ মহাগুণ্ডা বুলি সৰ্বজন বিদিত মই ভাবি লৈছো যে দীপকে তেতিয়া হেমেনক লৈ গৈছে যেতিয়া হলে মাৰপিট হবই কিন্তু মাৰি পেলাব বুলি ভবা নাছিলো হেহে মই মোৰ বুৱাৰী শ্ৰীমতী মৰমী দাস PW4 লৰা শ্ৰী বাধা দাসক লৈ দীপকৰ পুখুৰীৰ পাৰৰ ৰাস্তাৰ কাষৰে বুৱাৰী আৰু লৰাজনক থিয় কৰি হেমেনক চাব দিওঁ মই নিজেই দীপকহঁতৰ ঘৰলৈ সোমাই যাওঁ মই সোমাই যোৱা দেখা পাই ঘৰৰ কাঠিত লেপটপ জ্বলাই থিয় হৈ থকা বাটেহিয়া আগবাঢ়ি আহি কয় যে হেমেন ইয়াত নাই দীপকে হেমেনৰ আনিছিল হয় কিন্তু এৰি দিছে তেতিয়া মই কওঁ যে তোমালোকক গাহৰি গড়ালত ফালে কিহৰ চিঞৰ বাখৰ মোৰ ওপৰত বাটেহিয়ে কয় উত্তৰত বাটেহিয়ে কয় দীপকে তাৰ ঘৈণীয়েকক মাৰিছে তাকে চিঞৰিছে মোৰ মনত বিশ্বাস হোৱা নাই মই গাহৰিৰ গড়ালত আগবাঢ়ি খুজোতে ৰাতি ভালদৰে দেখা পাওঁ কি লাইটৰ পোহৰত ন ৰাতি পোহৰত ভালকে দেখা পাওঁ যে দীপক গড়ালৰ ফালৰ পৰা দৌৰি আহে আৰু মোক ধমকি দি কয় তোমাক কাক লাগে তেতিয়া মই কওঁ তুমি হেমেনক ক'ত লৈ গলা তুমি নিশ্চয় হেমেনক হত্যা কৰিছা তেতিয়া দীপকে মোক কয় হয় হেমেনক হত্যা কৰিছো বিচাৰি উলিওৱা আৰু বিচাৰি উলিয়াব নোৱাৰিলে কিন্তু সকলোকে কাটিম মই ভয়তে তাৰ ঘৰৰ পৰা ওলাই আহো আৰু ল'ৰা ছোৱালীক খুদাত তেওঁলোকে কয় যে হেমেন দীপক দীপুল আৰু ঘৰৰ এটাইবোৰ মানুহে গড়ালৰ কাষত মাৰি আছে আমি দেখা পাইছো. So her daughter and son-in-law said, মই দৌৰি হেমেনৰ ঘৰলৈ খবৰ দিবলৈ যাওঁ আৰু
য'ত লগ
আৰু আৰু ক'ত
য'ত লগ পাওঁ
লগ পাওঁ
তাকে
তাকে কওঁ যে দীপকে হেমেনক হত্যা কৰিছে. তোমালোকে হেমেনক বিচাৰি আনা. হেমেনৰ ভায়েক বুটা আৰু গাঁৱৰ কিছুমান লোকে হেমেনক গোটেই ৰাতি বিচাৰি নেপালে. পিছদিনা ৰাতিপুৱা মৃতদেহটো বিচাৰি পালে. Lastly, she said, মাৰি লৈ হত্যা কৰি পুখুৰীত পেলাই দিছে. পিছদিনা ৰাতিপুৱা হেমেনৰ মৃতদেহটো পুখুৰীত ওলোৱাত গোটেই গাঁৱৰ মানুহে নিশ্চিত হয় যে দীপক, দীপুল আৰু ঘৰৰ আটাইকে মিলি হেমেনক বাটৰ পৰা মাতি নি হত্যা কৰি পুখুৰীত পেলাই দিছে. Of course, in her 161, it cannot be got that she had seen anything. She met Deepak, she asked and Deepak replied. Others chased her. And then after coming back, when she met her daughter and son-in-law, son and daughter-in-law, they said that he was beaten up.
But he has also been acquitted.
All. Only Dipul and Deepak. So PW10, although she said in her trial statement that she had seen assaulting as well as dragging, in her 161, of course, she did not say that. That statement can again be, that evidence will not be an evidence in my humble submission. And the next, of course, it is homicidal. The death is homicidal, 6 numbers of injuries within 24 hours. Motive is there. It is in the statement of PW3. Lordship knows I need not place. PW3 page number, I'll just point out the page number. PW3 page number 14. 14. Yes, 13 last word. Page number 13 last word. As Hemen was in love with the sister of Deepak, as such they assaulted Hemen. In a case of circumstantial evidence, motive becomes important. So there is a motive. And one important fact is that PW number 6, the mother-in-law of Dipul, she, of course, in her trial statement said that I don't know about the occurrence at all. But in her 164 statement, she had narrated some facts. That I cannot, again, will not be an evidence because it will only have the effect of corroborating. Corroborating cannot be seen from trial.
161 can be used for corroboration.
No, 164. Corroborating the statement before the trial court. If someone says the same statement before the trial and 164, that will corroborate. Now, here she did not say.
Acha, she did not give the same version in her deposition as recorded in 164.
Lordship will see.
What is the 164?
164, Lordship will get at the end of the paper book. Page number 134. Reena Das. The Lordship. Page
She's
number
PW6.
PW6.
Hmm.
She said before the magistrate, about 5 years ago, members of the family of my brother-in-law, this is wrong, perhaps son-in-law, assaulted a boy, Hemen Das, to death. I gave my daughter Ranju Das in marriage with Dipul Das. At about 9 p.m. on the day of occurrence, when I went to bed after returning from work, someone called me. Returning from work, someone called me by knocking at the door.
Yes.
Knocking at the door of my house. Then I came outside and I was told that Deepak and son-in-law Dipul would go to fishery. Then I went to my son-in-law Dipul's house along with Shri Utpal, who had come to call me. Then I saw all the members of the family were in despair and learned that Harinath had thrown Hemen's body somewhere, dead body somewhere. As soon as I reached that place, Dipul went to the fishery. When I asked about the incident, Batehi Das, the mother-in-law of my daughter, told me that Deepak, Dipul and Batehi had assaulted Hemen to death. Then my daughter told me about the occurrence and I wanted to return from there, but Batehi did not allow me to return from there and confined me in a room. I spent that night in the house of the accused. I have this much to say. This could be an evidence under res gesta, but this cannot be used because of the bar. 161 statement also, if your lordship wants, I can read. Rina Das. And that's the one. This side one, eh? Rina Das. Rina Das. No, it's like Kultara. মই অৱস্থাত কি আছিলে যোৱা ইমান মই মোৰ সাক্ষী হওঁ এই গোচৰ সাক্ষী হওঁ যোৱা ৰাতি অনুমান 9টামান বজাত 30 সোয়েন্সো ডেটত মোৰ আহি থকা অৱস্থাত কামৰ পৰা আহি থকা অৱস্থাত গাঁৱৰ শ্ৰী দাসৰ ল'ৰা উৎপল দাসে মোৰ ঘৰত আহে আৰু দীপকৰ মাকে মাতা বুলি কয় মোক তেওঁৰ লগত লৈ আহিব কৈছে বুলি কয় আৰু মই কিবা বিপদ হৈছে সোনকালে যাব লাগে মই দীপকৰ ঘৰত আহোঁ আৰু দেখা পাওঁ যে দীপকৰ মাক বাটেহী দাস তেওঁৰ বোৱাৰী সোয়েন্সো ছোৱালী মৃত কি হাত দিবহি আহে মই ঘৰত সোমাওতে বাটেহীয়ে মোক সাবুতি ধৰি কয় যে বিয়নী হেমেনক মাৰি পেলালে নহয় হেমেনক মাৰি পেলালে মই প্ৰশ্ন কৰো কোনে তেতিয়া বাটেহীয়ে কয় হেমেনৰ আমাৰ দীপক আৰু দীপুল দুয়ো ভায়েকে মাৰি মৃতদেহ পুখুৰীত ফেনিদি নেকি গোপা ধৰি ঘৰলৈ আহিলক বিয়নী So in fact the mother of Dipul said that Deepak and Dipul had killed him and Pukhurit they had thrown the body in the pond. Same statement. Etia amar Dipulor logot mur swali bibahito hoy gotike Dipul aru bioni ho. Then she talks about the relation. The same statement in fact she made before the police also in 164 but then she was neither declared hostile, nothing was done. He denied. So these are the circumstances, Lordship, I have already placed. PW10 can be left out. So I would rely only on the first circumstance, taking him away, PW3 statement, recovery of the body, PW4 statement, thereafter the homicidal death, the motive, and PW6 statement, if at all, it can be taken as one circumstance, corroborating circumstance. This is Deepak. Dipul again will be difficult. Dipul taking away will not come to him. PW3 had said, I saw accused person assaulting. So accused person would include everyone, even Dipul. Then PW4 said Dipul
There
died.
were 6 number of injuries.
Six number of injuries.
No, please tell us one thing, or rather 2 things. If the court ultimately accepts that there is evidence to show that Dipul had played an active role in the confinement, restraint, or assault of the victim, and he had died in the same transaction, where Deepak had also had a
Role to play.
paramount involvement. Then first of all, can it be treated as evidence of common intent? This is number one. And if so, even if the trial court has not recorded any finding, or even if charge was not also framed under
No,
30
charge was framed.
charge was framed.
30.
So if charge was framed, then if there is evidence on record, then cannot the appellate court
Appellate
apply?
court go into.
Because this is in the event we accept this
Mm.
version.
Hmm.
If we do not, then the matter is different. But if a charge is framed, then the appellants cannot claim any prejudice, take the plea of prejudice,
Charge is there.
because they knew what is the charge
Ah.
and the evidence was led accordingly. Now, if the trial court has made a mistake by not recording this finding, that obviously can be noticed. But if the court finds that there are evidence to hold that there was common intent on the part of, there was meeting of mind, common idea was to assault him till he perishes, then regardless of who plays what role, can there be conviction with the assistance of 34? And can that finding be recorded by the first appellate court? That
That
is the
there
question.
won't be any bar, but here going with the facts of the case, except for PW3 stating that I had seen accused person assaulting, PW4 saying that he saw him tying, that is not there. Only one evidence is there against Dipul, is that the statement of PW3 accused persons he had seen. So even if we trial, there won't be any bar for the High Court to go into section 34 to see whether there was any common intention. Even if there is no finding by the trial court, there is conviction, there is charge. But here is a case, it will be difficult to bring common intention, because common intention, something I have to show by conduct, by some evidence. Here, I would have been able to do it had those statements were there, had those contradictions not been there in respect of PW4. PW4, that statement is not there that he had seen Dipul Das tying the accused with the mango tree. Only one solitary with evidence of PW3. I had seen accused person assaulting. Now, who are the accused? That again will not be specific. So common intention of Dipul will be difficult.
So you agree that there is no evidence against Dipul?
Dipul does only this evidence, PW3, PW4 there is contradiction, PW10 there is contradiction. Death is homicidal, PW number 6, only corroborating. So only one evidence that accused persons. That in my humble submission would not suffice. So common intention, I will be difficult to gauge in this particular facts. Deepak, there are enough evidence. But PW4 and 10, had those evidence been there, I could have taken him within the purview of common intention. But 4 and 10 have not stated before the police. 4 there is contradiction is proved. 10 to why 10 to, even if I go to 161, even then it's not there. No. But subject to correction, if your lordship finds some common, I am not able to in my humble submission. এইটোতো ফোৰটো কোৱা নাই ন এৰিয়া ক'ব চাওঁ
নাই, নাই,
হেৰিজনী
বন্ধা কৰা।
মৰমী
নাই, কৰা নাই। কৰিলো।
মৰমীটো বিপুল এইটো কৈছে গোটেই মাৰাই দেখিছো
এতিয়া মাৰা দিলে, all accused.
those I cannot bring
Okay, দম দিয়াটো হয়। কালিৰ পৰা
All right, now can we just have a look at the judgment, impugned
Love.
judgment? Where is the final?
Page 107, para 20.
Yes, 107.
Page 107, para 27.
Yes.
Coupled with the aforesaid decision and a meticulous scrutiny of the evidence on record, it is appearing that there is no dent in the prosecution case. All the PWs,
অলপ আগৰ পৰা
internal page 20.
অকমান আগৰ পৰা the fact that
All the PWs before the police, before court, make one single consistent statement that it is accused Deepak took Hemant from the culvert at his house in front of PW 1 and 2. This was seen by PW 10, and PW 10 informed the matter to PW 3, who went to the house of the accused, noticed accused Deepak and Dipul assaulting Hemant. PW 2, hearing of the incident, went to the house of the accused Deepak. She too witnessed accused Deepak, Dipul assaulting Hemant. Then Deepak took Hemant on the backside of his house. She heard one sound and thereafter Hemant was not seen. PW 3 came twice, and on second time he did not see Hemant, and he was told by accused Deepak that they have freed Hemant. PW 10 also noticed accused Deepak Dipul assaulting Hemant when she went to their house. In the early morning, dead body of Hemant recovered and accused persons left their house. The circumstances appearing in the case form complete chain of circumstances. The statement of eyewitnesses goes against the accused. That prove only the guilty of accused Deepak and Dipul.
even little before that the findings of the that is a conclusion oh that was one finding little before that paragraph 19 lordship can see the fact of the case the fact that accused Deepak brought Hemant to his house at 7:30 which is noticed by 1, 2 and 10 on being proved at 7:30 and thereafter assaulted Hemant by accused Deepak and Dipul being noticed by 3, 4 and 10 and thereafter Hemant was untraced and on the next morning his dead body was recovered and the fact that backward of the backyard of the accused house which is an open paddy and pond where no residential house is present is very easy to carry the dead body from the house of the accused Deepak and then to throw in the pond recovery of blood stain in their house blood stain actually was recovered from the pond. Perhaps. And that blood stain they say of Dipul in the 313 statement. I'm not able to understand. Absconding of accused Deepak and Dipul connected all circumstances without snap that only proved the guilty of the Deepak and accused Dipul and Deepak. Accused Deepak and Dipul failed to show that they were separated from deceased soon after they were seen together and thereafter deceased was seen alive and then he died. But this is not coming from the cross-examination of PWs, but prosecution evidence connected the every chain of circumstances against the accused Deepak and Dipul. PW 19 stated that seized bloodstained earth from the floor of the house and compound of the accused, and PW 5 stated seizure of bloodstained soil motorcycle in his presence. Defense could not give any answer where from blood comes to their house. And defense also fails to show why accused Deepak and Dipul left the house immediately after the incident. Lordship can see the Caesar list once of the bloodstained earth. Lordship can just
Page
see the
116 minutes.
Caesar list of the bloodstained earth. Page 116. There they say, which was found at the place of occurrence. In connection with this, time and Caesar 8:30 AM 15. Place of Caesar is at place of occurrence Dahudi house, premises of Deepak Das. There they find one piece of earth with blood stain. Page number 116. And a motorcycle in broken condition. Kalyan also 151.
So both the accused persons are in jail.
In jail, man.
Bail prayer rejected.
Bail prayer was, paperwork was to be prepared, my lord, so that hearing could be heard early, my lord.
No bail prayer made.
Bail prayer was made, my lord. In that bail prayer, my lord, but lordship directed that paper would be made forthwith so that the hearing could be taken up early, my lord.
That is pending.
I had disposed of it.
Oh, disposed of. So this is the piece of art they were talking of. Then again, Kalyan Das is in his 161 statement I have seen, he said that some earth were taken from near the pond because the body was found in his pond.
May I read the 161 of Kolyandas, my lord? May I read the
You
161?
just take your seat. Let her finish. Yes.
So this is the blood
Take your
stain.
seat, Mr. Mal.
This is the blood stain that they were talking of, motorcycle in his presence.
Hmm.
Then I'm coming to paragraph 20 again. Defense could not give any answer where from that blood comes to their house. The defense also failed to show why Deepak and Dipul left the house immediately after the incident. PW8 evidence is that getting information from some villager gathered in the house of accused and created nuisance alleging that they caused death of Hemen. He went to the house of accused, found police, and with the help of the police, situation was put under control. And he put his signature in Exhibit 3 Caesar list by which IO sees motorcycle of Deepak. At that time, accused person left their home, hide somewhere. His evidence also pointed the seizure of electric iron because there were some burn injuries on the body. Blood-stained earth, person keeping the electric iron in the house which is used to press the cloth means that show that person having electric connection. The butterfly mark burn injury on the chest may be due to pressure of hot iron twice in the chest. The several injury mark, more specifically on the injury mark of the lung, chest, a serious injury and injury on the vital organ of MN caused his death. Last scene theory, of course, will not be again very relevant. The last scene theory, noticing assault, recovery of the dead body, absconding of the accused, form a complete chain against the Deepak Dipul without any interruption, together with statement of eyewitnesses 3, 4, and 10, draws only guilt of guilt of Deepak and Dipul and no inference of innocence. Then, Lordship, there is a Supreme Court judgment that was referred on last scene. Then a few Supreme Court judgments, 23, 24, and 25. 26 is again a finding. Going through the aforesaid decisions of the Honorable Apex Court, it is now crystal clear that when prosecution case is hinged on circumstantial evidence, prosecution must prove every link of the chain of circumstances, and it must be one complete chain of circumstances as must bring guilt, no inference of innocence, cannot, and the circumstances only connected to a conclusion of fact, which proves only guilt. This is the finding.
All right. Anything else?
The bloodstain, Lordship, can one see 3-1 statement once of Deepak. Deepak's 313 statement,
Page number?
39. Deepul is 38. Deepak is
39 is part of Dipul statement.
Deepul. 39 is Deepul. 42 is Deepak. 42 Deepak, the relevant part, Lordship, will go to the next page, page number 44. There they talk of the piece of earth with blood clots in it. The answer that he gives, answer to question number 13. The dry blood clots found in the floor of our house, which is marked as B in the sketch map, are the dry blood clots of Dipul Das, son of Fultara. This is again wrong. And at that time, we were not present. And that blood clot was not sent for FSL also. Nothing
So what is the relation between Deepak Das and Dipul Das?
They are brothers, our other cousin brothers or brothers.
I don't know, it can be both.
Because in 161 statement, they said Bhaik, Duzon Bhaik, Moromi Das, I think. They are brothers.
See the father's name.
Huh. Same, yeah? This one. 30,
Same
Nine.
father.
39 is Dipul. So father is Bathoram, Dipul's father is Bathoram, and Deepak's father is Bathoram. Yes, they are brothers. Dipal and Deepak. Otherwise, apart from that, no evidence. The blood clot were not sent for FSLR also. I cannot take any advantage to it.
This
But-
appears to be some localized version of some
Hmm.
form of honor killing here.
Hmm.
Hmm.
Localized version of honor killing is. And that will again not be a ground for conversion and all, because there can be some provocation, there can be some grave and sudden, but
What provocation?
it's a motive. It cannot be said to be grave and sudden provocation.
We are only thinking the incapability, inability, lack of understanding
Hmm.
of the IO
Yes,
prosecution.
had the investigation been done more properly,
Should these be so casually let out? That's what we keep thinking every day.
and this answer to question number 13 is same in respect of all the accused. They've all stated the same. Blood clot of our house belongs to Dipul Das and all that. Kailanda said in his 161, it is taken from near my pond.
But is there any injury report of Vipul Das? Any injury report?
No.
No. In fact, the other case, there's an injury. No, not here.
The
No
whole
injury.
thing is turning out to be a very easy escape route for the criminals.
When they were arrested, I'll just see when were they arrested? Deepak Dipul, Asak Rosak, from the case. Like absconding is taken as a circumstance under section 8 of the evidence. See when they were arrested. This day. Deepak Das statement. 8-6.
Hmm.
Even 8-6 over there. 8-6, because the statement was recorded on 8-6.
All right. Anything else?
These are my humble.
Yes. Anything you want to say in reply?
Well, taking away part is there, my lord, but taking away part is there, PW 1 and 2.
Yeah, don't repeat
Hello?
something you have already argued.
See, my lord, my learned senior friend, senior for the state, my lord, stated it would be an omission, my lord. But I would humbly defer, my lord. It becomes a contradiction, my lord, because in Ashok Dev Burma, that FIR becomes 161. It can be used to contradict the maker, my lord. That has been done in this case, my lord. And PW3 was confronted with the contents of the FIR is 161, the actual 161, and he has said nothing. He has stated that he has not stated and so and so. Then the only thing that remains for both, my lord, is the taking away and Boromi, my lord, PW4. Or again becomes a contradiction. And 6 has not been made hostile, my lord. That becomes binding on the prosecutor, PW6. And one more, if lordship goes to PW6 is 164, my lord.
Who's 160?
PW6, my lord,
You just seen it.
my lord.
PW6 has given the correct version in 164 and 161.
In
Then
that,
in the deposition, she was under some pressure threat, which is visible.
in her 164 also, Lordship would see, my lord. Odinath had disposed of the body, my lord. I'm only guessing, my lord. People comes after the fact, my lord, towards the pond, my lord.
All right. Anything else?
Well.
Had Mr. N. Mahajan, learned counsel appearing for the appellant, also had Ms. S. Jahan, learned APPSM appearing for the state. Arguments concluded, judgment reserved.
Obliged.
Obliged, my lord. Very well.
Daily list for hearing item 1 and 2.
Merit with Lordship. In this case, Lordship, appellants have been convicted under section 326A IPC. Section
You are appearing,
in item number 1, Lordship.
and what is, it's by the other accused person,
Yeah, that is.
co-accused,
Two.
convicted both.
Both convicted.
Conviction is under,
Under section 326 A IPC, acid, reverse hard by working acid attack.
sorry?
Acid attack, acid. 120B, we do 34. 14 years sentence is 14 years imprisonment and to pay compensation of rupees 12 lakh to the W8.
This is a Arunachal matter.
Arunachal matter.
Why it has been heard here?
Initially, during the period of COVID, Lordship,
COVID is gone now.
At that time, bench is not available, might be.
COVID is now over.
item number 2 was first listed here. Subsequently, item number 1 was.
You don't want to travel to Arunachal? It's nice place to visit, Mr. Chaudhary. What do you say?
My lord, both sides have appeared, my lord, informant counseling also from here only, my.
All right. Yes,
Lordship, FIR is at page 4.
yes.
So the exhibit 1 is dated Longding 3rd January 2019. Saturday around 7:43 hours, one unknown miscreant suddenly came to the PK mobile shop located at Main Alley, Longding, and throw an acid from the jug at the face of my elder brother Muhammad Anwaruddin, son of Mujambil Ali, causing grievous injury on his face and ran away. While another 6 persons, including the customers found present at the shop, were also inflicted injuries by acid throwing, namely Sri Kila Romrang, Shubhas Das, Aftaruddin, Mona Das, Nanwang Ramrang, Rajibur Rahman. It was registered on, there is little discrepancy. It was registered on 3/2/2019. But the informant is 3rd January. 3rd January, registered on 3/2.
3-2 is correct or some mistake here?
As per evidence, 3/2 is correct.
As per evidence, 3/2.
But charge is also framed under on it is as if it was on 3rd January. Evidence 3rd February. Next page is charge list. May I please read lordship firstly,
Yes.
page 5. So firstly, that you at about 3:04 p.m. on 3/1/2009 at Longding Market, you Sri Ahom Ahangsa with myself lordship and Sri Punam Wang have agreed with Nipen Das. Nipen Das is the appellant in the item number 2. To murder cause grievous hurt to the victim, namely Anwaruddin, and besides the said agreement that you caused the grievous hurt by throwing acid, which is punishable with imprisonment for life, and thereby committed an offence punishable under section 120B within the cognizance of this court of session. Secondly, at about 17:43 hours on 3/1/2019, at the shop of victim situated at Longding Market, accused Uman Wangau pretended himself to be customer and accused Aham Wangsa had threw a jug of acid on the face of Anwaruddin, causing grievous injury, which is an offence punishable under section 326A IPC within my cognizance. The above offences are committed by you in furtherance of your common intention punishable under section 334 IPC within my cognizance. So this Uman Wangau has been acquitted. Only two. Now, may I please formulate my argument, lordship? First, on the issue that whether that it is a case of acid attack, acid, that the substance was acid is proved by the prosecution or not. PW 1 to 4, 5, they are also injured, some injured. PW 8 is the main victim. Their evidence is some said that some acid was thrown, burn injury, they felt the burn injury. Now, PW 10 is a doctor. What doctor said, that we can look at. PW 10 doctor is page 28. May I please read that? On 3/2/2019, I was posted at CHC Longding as EMO. On that day at about 6 p.m., 7 numbers of injured persons came to the hospital for treatment. They are Anwaruddin, Akhtaruddin, Pilar Onrang, Nanwang Rangrang, Santosh Das, Mona Das, and Rajibur Rahman. They had complained that they sustained burning injury allegedly caused by acidic substance. This is allegedly. On my examination, I found that Anwaruddin sustained 3rd-degree burn on face, upper arm, and neck. There was a corneal damage to the patient. The type of injury was grievous. I referred him for higher medical treatment. On my examination, I found that Akhtaruddin sustained 3rd-degree burn on both lower extremities legs. The type of injury was grievous. I referred him for higher medical treatment. On my examination, I found that Pilar Onrang sustained simple burn on both hands. On my examination, I found that Nanwang Rangrang sustained simple burn on both hands or face. On my examination, I found that Santosh Das sustained simple burn on face and both hands. On my examination, I found that Mona Das sustained simple burn on lower extremities, legs. On my examination, I found that Rajibur Rahman sustained simple burn on right lower extremities. Exhibit number 14 to 20 are the injury reports submitted by me, and exhibit 14 and 20 are my signatures. Cross examination. I cannot say the age of injury. The patient came themselves. The injury caused by dilute acid. The injury sustained by the patient may also be caused by throwing boiling water. There is a doubt. It may be caused by boiling water. Now, I please take a look to PW7, the IO.
Page number?
It's 16, 17. 17. On 3/2/2019, page 17.
Yes.
On 3/2/2019, I was posted at Longding PS as SI of police. On that day, written FIR was one written FIR was filed by the Shahnaz Hussain, alleging that around 7:43 hours, one unknown miscreant had come to PK Mobile Shop, that is the PO of the case, and threw acid from a jar on the face of his elder brother, Muhammad Anwaruddin, and ran away. Another 6 persons who were standing near the PO has also sustained injury to acid. On receipt of the FIR, Longding PS case number 7 of 2019 under section 326A IPC, tested by the officer in charge, and the same is endorsed to me for investigation. During investigation, I forwarded all the 7 victims to CHC Longding for examination and treatment. I have also submitted requisition for injury report of the victim according to the nature of injury. Accordingly, I have received the injury reports of the victim, wherein it is reported by the doctor that two have sustained grievous and burn injury and 5 have sustained simple injury. I have visited the PO and prepared draft sketch map. I have recorded the statement of informant and the victims as provided under section 161 CRPC. I have seized the clothes of victims having sparkle of acid and the jar which was used for throwing acid. The seized materials forwarded to FSL Kolkata for expert opinion, which is yet to receive. The prosecution did not prove that it was acid on the forensic.
That you have said day before yesterday.
Yes, Lordship.
How many times you will say that?
Sorry. Next, Lordship.
Twice today, twice day before yesterday, and this is the 3rd time. Yes.
Now, Lordship, PW 1. The
Page number?
page number 7. Page number 7. What is their version? Whether they could identify who caused this injury. Please record. On 3/2/2019, it was Sunday, and there was cricket match of India. After
Where are
watch-
the witness numbers written in this pages? In page 7, why does one find that it is PW7?
PW1, Lordship. Page 7 is PW1.
Where does it find that it
It's
is?
a
PW?
right and top, Lordship.
Oh. All right.
On 3/3/2019, it was Sunday, and there was cricket match of India. After watching the cricket match, I went to the mobile shop of my elder brother, namely Anwaruddin, as on that day, my shop was closed. At about 6 p.m., I went to the market for purchasing some vegetables. When I was in market, I have received a phone call from my brother who asked me to come to the mobile shop and close the same. I rushed to the mobile shop of my brother and seen that lots of people were gathered in front of the shop. On reaching the place, I have found some odor which created burning sensation in my nose. I inquired the people gathered there who has told me that someone has thrown acid on Anwaruddin. By the meantime, Anwaruddin was taken to hospital. After the incident, I have submitted FIR before the Longding PS. I have not alleged any person in the FIR, as during that time I did not know who was the miscreant. The accused person, namely Nipendra alias Kala and Ahom Wongsa, are identified by the witnesses. Exhibit 1 is the FIR filed by me, and 1A is my signature. Cross-examination. For Nipendra. It is a fact that during the time of present incident, I was not at the PO. I do not know who has thrown acid on Anwar. I have not seen who has thrown acid. Cross-examination for accused Ahom Wongsa. It is a fact that during the time of present incident, I was not at the PO. I do not know who has thrown acid on Anwar. I have not seen who has thrown acid. PW2, page 9. Rajiv Rohan. On 3/2/2019, it was Sunday, and on that day at about 4:30 p.m., one Santu Das took me to the mobile shop as he was to receive some money from the shopkeeper. When I was talking to the shopkeeper, there was 2 other police personnel who were talking to the shopkeeper on the nearby counter. During that time, one person has thrown acid on the shopkeeper of the mobile shop, namely Anwaruddin. Some of the acid also fallen on my leg. During the time of throwing of acid, the person was covering his face by some cloth and I could not identify the person. After the incident, there were hue and cry and the people started to run. I also ran away from the place. I know the accused person standing on the dock, namely Nipen Das alias Kala and Ahom Ohangka. Cross-examination for accused Nipen Das. It is a fact that during the time of present incident, I was present at the PO. I do not know who has thrown acid on Anwar. I know accused Nipen Das alias Kala as a shopkeeper of one mobile shop. Cross-examination for accused Ahom Wangsa. It is a fact that I do not know who has thrown acid on Anwar. Accused Ahom Wangsa used to sit at the top of Nipen Das. Carry PW3. PW3, Subhash Das. Page 11. On 3/2/2019, it was Sunday. I was about to receive some money from Anwaruddin. Accordingly, I, along with Rajima Rahmat, went to the mobile shop of Anwaruddin for taking my money. When we were talking to Anwar, two more customers came to the mobile shop. During that time, someone has thrown liquid substance like water on Anwaruddin. There was smoke. We thought that hot water might have thrown. Some sparkle of liquid substance fallen on my face and hand. I have realized that it was acid which was thrown upon Anwaruddin. Thereafter, I went to medical for treatment of the injury. I could not see the person who has thrown acid. The other two customers are police personnel who came to the shop are present today. I know the accused Nipen Das alias Kala. Cross-examination. It is a fact that during the time of present incident, I was present at the PO. I do not know who has thrown acid on Anwar. I know accused Nipen Das alias Kala as a shopkeeper of one mobile shop. Same for Ahom also. It is a fact that I do not know who has thrown acid on Anwar. Then another injured PW4 is 13.
So how many accused persons were charge sheeted?
3%.
Three.
One has been acquitted.
One has been acquitted. All right.
Page 13, PW4. On the date of incident, after closing my shop, I was going towards my residence. During that time, one Subhash Das, who is also from my same colony, has asked me to wait and told that we will go together. During that time, I was standing, all of a sudden, I have felt that some water-like substance has fallen on my leg and I sensed burning sensation. Thereafter, I went to medical. I have not seen who has thrown acid. Cross-examination declined. Similar is PW5. Page 14. On the date of incident, in the evening, I went to the mobile shop of Anwar for mobile recharge. At this mobile shop, I was standing at the counter and Anwar was noting my mobile number before recharge. All of a sudden, one unknown person has thrown some liquid chemical substance on Anwar. Some of liquid fallen on my hand and I felt burning sensation. After the incident, people started to run. I have not seen the person who has thrown the chemical. I know it was Nipen Das alias Kala. Cross-examination. I cannot say the exact time, but it was evening. I know it was Nipen Das as a shopkeeper. For others, declined. Now, two other persons injured are PW8 and PW9. They are lengthy. I'm not going. I will go to them later on. Now, PW6.
So how the accused persons were identified?
This is PW6. His 164 statement has been taken as a substantive piece of evidence to corroborate my retracted confession and some contradictory evidence of PW8. CCTV footage, CDR, which were not proved. CDR has not been proved as per law. There is no CCTV footage. It was never seized. And PW8 says that police showed him CCTV footage from there. There he identified me that I have told from my gesture and my clothes. No.
Yes.
Evidence of PW6. Important. Page 15. Manai Wangsa. On the date of incident, I along with Ahom and Puman went together. Puman was with me. Ahom went to the residence of his brother. Ahom has asked us to meet him at PK Mobile Shop. Accordingly, I along with Kumon went to the mobile shop and was waiting for Aham. During that time, I have heard the sound of shouting from the mobile shop and turned towards the mobile shop to see regarding the shouting. I could not identify the person as to who has thrown acid to the shopkeeper. A boy who has thrown acid ran away from the place of occurrence before being identified. On that night, I stayed with Aham and Kuman. After 2 days, they went to their village and I was at Longding. Police arrested me. He was also arrested. On the next day, police has arrested Aham as we were together. Allegation against me for arrest by police that I was with accused person Ahom and Puman. The accused persons, namely Puman and Ahom, were identified by witnesses. Cross decline. The cross for Ahom Wangsa is one line. I know accused Ahom and Puman as we are friends. They are from my village. The Lordship, from this evidence, he was not declared hostile. This evidence before the court, this much is there. Now, may I please take a look at the judgment, how these evidence, his evidence has been dealt with. Judgment starts from page 58, relevant part of the page 81. Lordship. Paragraph 39.
Page,
Page 81. Paragraph 39.
yes,
In the present case, during investigation, the present case, the IO has forwarded PW6, the Manai Wangsa before the magistrate for recording of his statement as provided under section 164(5) of CRPC. Planet JMFC Longding, the court witness herein has recorded the statement of Manai Wangsa, exhibit 9 herein. PW6 has stated before the magistrate that on 18/1/18, he came to Longding from his village Konsa to play football tournament, as he was the goalkeeper of the team AFC Konsa Football Club, along with his team member, and thereafter stayed at Longding in Puman Wangnau rent house, as he is the friend from Konsa village. After a few days, he started to take tuition for classes 1 under UKG and LKG. One day, Ahwanse called him in his mobile phone, asking him and Puman Wangau to come to the market, but they denied to come to the market. Thereafter, Puman came to the rented house running as he was breathing first and asked them to come to the market. Thereafter, he and Puman Wangau accompanied Ahwansa to the market, thinking that he wants to buy something from the market. On reaching market, Ahwansa took them to the mobile shop of Nipendas, and then Nipendas and Ahwansa went backside of his mobile shop, Nipendas's mobile shop, and they started speaking secretly there. He heard Nipendas saying, "Jo hum bola hai, aisa karo. Whatever I say, do it accordingly." Then Ahwansa asked him and Puman to wait for him near Anwar's shop. Then they came downstairs near Anwar's shop, and from there he went for urinating at the backside of the bookstore. When he came back after urinating, he found Puman smoking near Anwar's shop. So he also went near Puman who was at Anwar's shop. There he saw one person coming from downside area of Anwar's shop wearing dust mask which is normally used at the time of cold, on his face and putting both of his hands backside of his body, carrying one jug. While he saw the person from near, he recognized that marked person is none other than Ahon Wangsa. He recognized Ahon through his clothes, physical appearance, and also the cut mark on right cheek of Ahon, which was also clearly visible as the dust marks does not cover the whole face. Ahon Wangsa came to Anwar's shop and threw a jug of acid on his face, and Ahon ran away from the scene. Anwar started crying and shouting in pain. After seeing all these incidents, he and Puman went back to their rented house in a shock. While returning to the house, they found Ahon standing near a small tree near Labour Colony in between Circuit House and helipad, but they did not spoke to Ahon, and they directly went to their rented house. At around 8-9 p.m., when they were sleeping, Ahon Wangsa also came and slept in his bed without speaking to them. On the next morning, his tuition student came to their rented house, and thereafter he started taking class. He started avoiding and stopped talking with Ahon Wangsa. After a few days of the acid attack incident, Ahon went to Pangchau on 5/3/2018 at around 9 to 10 p.m. Police personnel came to their room and took him and two of his friends to police station and inquired about Ahon. He informed the police personnel that Ahon went to Pangchau, and after that they were dropped to their rented place by police. On the next morning, when he was coming back after attending church near Circuit House, he saw police vehicle near rented house and saw police personnel bringing Ahon Wangsa from their rented house. He was waiting near the police vehicle, watching Ahon and police coming towards the vehicle. And when police reached near him, police personnel asked him to go inside the police vehicle and accordingly went to the police station on vehicle. 40. Manai Wangsa, who is examined by the prosecution as PW6 in present case, has become hostile and deposed that even though he was present at the place of occurrence during the time of throwing acid upon victim, he could not say as to who has thrown the same. He stated before the court that during the time of throwing acid, the miscreant came with mask and he could not identify him as he ran away after throwing acid. Planet PPS submitted that Manai Wangsa, who happened to be the friend of accused Ahon Wangsa and Uman Wangau, hailing from same village and residing at the same rented room at Langding, is an interested witness. As PWC has turned hostile, the portion of his deposition as well as statement under 154.5 should be 164.5 recorded by magistrate, which corroborated with the fact of the case be considered. I have observed that Manai Wangsa deposed before magistrate during recording of his statement under section 164.5 that he saw one person coming from downside area of Anwar shop wearing dust mask, which is normally used at the time of cold, on his face and putting both of his hands backside of it, body carrying one jug. Above statement is corroborated with the present case as the miscreant came covering his face with a mask and as acid thrown by jug, which is seized by PW7 by Sejano Exhibit 2. He further stated that when he saw a quote, when he saw the person from near, he recognized that the masked person is none other than Ahon Wangsa. He recognized Ahon through his clothes, physical appearance, and also the cut mark on right cheek of Ahon, which was also clearly visible as the dust mask does not cover whole face. Ahon Wangsa came to Anwar's shop and threw jug of acid on his face, and Ahon ran away from the scene. Anwar started crying and shouting in pain. Unquote. I have physically seen the cut mark on the cheek of accused Ahon Wangsa while he is produced during the entire hearing of the case, which corroborates the statement of Manai Wangsa that he identified accused Ahon from his wearing apparels and cut mark on cheek above the face cover. Manai Wangsa has deposed before magistrate that he informed the police personnel that Ahon Wangsa went to Pangchau. And case record shows that the next morning, police has apprehended Ahon Wangsa from Pangchau. The corroborated testimony of Manai Wangsa is reliable evidence to hold that it was Ahon Wangsa who came covering his face mark and thrown on Anwar. Now, this is the dealing lawsuit. The finding that he was a hostile is my humble submission is perverse, because hostile court cannot declare hostile like this in a judgment that he has been declared hostile. That is a procedure during if the prosecutor is not he is not supporting the prosecution case, he is to be declared hostile then and there with the permission of the court under section 154 of Evidence Act. Cross-examination is to be marked. He is to be cross-examined, and 164 statement is to be brought on evidence as a contradiction. Now, this way corroboration would be. Now, Lordship,
Yes,
I without giving other evidence on this point, whether it was according to law, I beg to rely upon this.
no, you see, there's nothing
Because one by
much
one.
on it. If it is not a hostile witness,
Yes.
then it helps the prosecution case even better.
No.
The learned judge made a mistake here, you're right. But that doesn't better your chance on this point.
Judgments.
Because the judge says that the cut mark in the face of the accused was verified by the judge himself. And on that basis, he found that the version given by PW6 stands corroborated on the above count. But in doing so, the judge has observed that he was a hostile witness. He was not hostile witness, but he did not support the prosecution case in toto. He said that the boy could not be identified.
What has been recorded here, it is a statement in 164 statement. 164 statement is not a substantive piece of evidence. It can be taken for either corroboration or for
And that's correct,
contradiction.
that's correct.
Now, if the
So
prosecution,
we granted that he was not a hostile witness.
yes, if he is not a hostile witness, these 164 statement cannot be taken into consideration
All right,
because it was not available to the prosecution.
all right.
Because
Hmm. We'll consider that, yes.
then we can go on the next paragraph. Lordship. This is a magistrate who recorded the confession as well as this 160%. Because next point I will submit on restricted confession. Paragraph 42.
Yes,
Court witness Srimati A.P. Kapoor, who has recorded a statement of witness Manai Wangsa as provided under section 165 CRPC, has specifically deposed that Manai Wangsa has deposed before her that he had seen Ahon Wangsa coming to the place of occurrence, holding a jug on his hand and covering his face. Manai has identified Ahon from his cut mark on the cheek and wearing apparels with physical appearance. Ahon went to the shop of Anwaruddin and thrown the liquid substance in the jug on the face of Anwaruddin and ran away. He was exhibited the statement of witness Manai Wangsa Exhibit 9, along with the signature of Manai Wangsa as well her signature therein. During her cross-examination, the above material fact could not be rebutted, and there is no contradiction raising any doubt upon the materials on record, as everything is corroborated from the fact of the case. PW7 has also confirmed recording of the statement of Manai Wangsa under section 164.5 CRPC. Now confession, paragraph 43. Accused Ahon Wangsa has confessed his guilt in the present case, and accordingly his confessional statement is recorded by learned JMFC, Longding Exhibit 10. During his confessional statement, accused Ahon Wangsa has deposed before learned JMFC that on 3/2/2019 at about 3:04 p.m. the Nipendas asked him to kill Anwar with doubt, that is Anwar ko kaat kar khatam kar do, upon which he asked as to why. Then Kala said that whenever he used to go to Tinshukia for taking stuff for his mobile shop, and Anwar used to block him and take his stuff like mobile and accessories. He said won't be able to kill him by doubt. Then Kala said he will give him an easy way to kill Anwar, and then he went to his house and brought one jug full of some liquid in bracket acid and gave it to him and asked him to throw it in the face of Anwar and run from the scene, and thereafter take rupees 10,000 from him in the next morning. Accordingly, he took the jug of the street and threw it in the face of Anwar and ran away from the scene. After one day, Kala called him and asked him to come to his house. When he reached his house, Kala gave him a mobile phone with a SIM card and asked him to call Anwar and tell him that acid was thrown to his face because Anwar had raped his girlfriend, Ahon's girlfriend, and then Kala also asked him to call Superintendent of Police, Longding, and tell him that he threw acid on the face of Anwar because Anwar had raped his girlfriend. Thereafter, Kala told him to destroy the SIM by chewing it, and accordingly, after calling Anwar and SP Longding, he destroyed the SIM by chewing, and thereafter he returned the mobile phone used for calling Anwar and SP Longding to Kala at his shop. After 4 or 5 days of incident, he and Puman went to the house of Nipendas and asked money, but he gave only one phone, Redmi MI 6A mobile phone, mounting to rupees 6,000 only, and denied to give him any money. Thereafter, they took the mobile phone and went to their house, and on the next day, he went to Pongchau and Puman went to Konsa from there. He was being arrested. From there, he was being arrested and brought to Longding. Accused Ahon Wangsa has retracted his confession, and during his cross-examination, examination under 313 of Criminal Procedure Code by this court, he has stated that he does not know anything about the confession. Honorable Supreme Court in a case reported in just laid down that it is not the law that once a confession was retracted, the court should presume that the confession is tainted. As a matter of practical knowledge, we can say that non-retracted confession is rarity in criminal cases, To retract from confession is the right of the confessor, and all the accused against whom confessions were produced by the prosecution have invariably adopted that right. It would be injudicious to jettison a judicial confession on the mere premise that its maker has retracted from it. The court has duty to evaluate the evidence concerning the confession by looking at all aspects. The twin test of a confession is to ascertain whether it was voluntarily and true. Once those tests are found to be positive, the next endeavor to see whether there is any other reason which stands in the way acting on it. Even for that, retraction of the confession is not the ground to throw a confession overboard. Above decision is also relied upon by the division bench of solution. Paragraph 43. Let us examine as to whether the confession made by the accused Ahan Wangsas is voluntarily or as to whether it is corroborated with other evidence on record. I have perused from the exhibit 10 confessional statement and seen that on 8/3/2019 at around 11:30 a.m. accused Ahan Wangsa was brought from judicial custody Longding before learned JMFC Longding for recording of confessional statement. Before recording of the confessional statement, the accused was given 2 hours reflection time at the court premises. It is explained by learned magistrate that she is not a police personnel but a magistrate. Accused has disclosed before learned magistrate that no police personnel or other personnel forced him to confess before the magistrate. He has also asserted that he knows that he is not bound to make confession, but he wished to make the confession to tell the truth. What he did, I have also observed that on the bottom of the confessional statement, Lana JMFC Longding has made a memorandum that she has explained Ahunangsha that he was not bound to make a confession and explained that if he does so, any confession, it may be used as evidence against him. And she believed that the confession was voluntarily made. The confession was taken in her presence and hearing and was read over to the person making it and admitted by him to be correct, and it contains full and true account of the statement made by him. 46. I have perused the case record and seen that in the present case, accused Ahunangsha was arrested by IO on 6/2019, and the same day he was produced before magistrate and remanded to judicial custody. On 8/2019, the IO has filed an application before the learned JMFC Longding for recording of the confessional statement of the accused persons. Accordingly, on 8/2019 itself, accused Ahunangsha, who was in judicial custody for 2 days, along with accused Nipen Das and Puman Wangno, was produced before the magistrate by jail authority as ordered by learned magistrate. The accused persons, namely Nipen Das and Puman Wangno, even though initially expressed that they will confess before the magistrate, but after explanation of the consequence of confession, a learned magistrate, as provided under section 164 of CRPC, declined to make any confession, and accordingly their confession were not recorded by learned JMFC Longding. Accused Ahunangsha has voluntarily expressed his willingness to confess before learned JMFC, and accordingly he was again provided 2 hours as reflection period in presence of court officials before recording of his confessional statement. In view of material available on record and the procedure followed by learned JMFC Longding, it is observed that the confession is voluntarily made by accused Ahunangsha, and as such, there is no impediment for placing reliance upon the confession made by accused Ahunangsha. Now, Lordship, this confessional statement, in my humble submission, does not fulfill the mandatory requirement of section 164. Although learned trial judge has improved, he has written, she has explained Ahunangsha. From the exhibit 10, it is at page 124. There is a deliberate deviation. I'm using deliberate because I made sure to understand what he has done. 124 is the confessional statement, page 126 is the particular this prescribed memorandum. He wrote, I have examined the Ahunangsha that he is not bound to make a confession, and that if he does so any confession, it may be used as evidence against him, and I believe that this confession was voluntarily made. It was taken in my presence and hearing and was read over to the person making it and admitted by him to be correct, and it contains full and true account of the statement made by him. May I please refer to section 164 for
You have finished reading all the witnesses?
No, Lordship, 8, 9 is there.
Let us finish the witnesses first.
Lordship. Seven, I have to go. 8, 9, and 10 is doctor. On court magistrate, CW1 is the magistrate.
Let us see the witnesses
CW.
one by one.
CW8, Lordship, page 21. He is the main victim here. Main injured. May I please?
Page 21.
21. May I please?
Yes.
I'm a businessman and I have one shop where I used to sell mobile at Longding town. My mobile shop is located towards the downside of market. My shop was running well. After a few days, accused Nipendas has opened another mobile shop at the Longding main market. I used to get the mobiles and other materials for sale from Dimapur. Nipendas has also started to purchase mobiles from the same shop at Dimapur. The shopkeeper at Dimapur, where from we purchase mobiles, is from my native village. Sometimes Nipendas used to accompany me to Dimapur for purchasing mobiles. We used to stay at the residence of the shopkeeper at Dimapur and used to have our fooding together. Sometimes we used to purchase materials from Tinsukia. I even
He is the
used to-
victim. He is the victim.
He is the victim, main victim. He is the shopkeeper.
Yes.
We used to stay at the residence of the shopkeeper at Dimapur and used to have our fooding together. Sometimes we used to purchase materials from Tinsukia. I even used to give assurance on behalf of Nipendas while purchasing materials, and when Nipendas used to have shortage of money. Our shops were running well. Nipendas, who married one local girl from Longding, had several acquaintances with the local peoples, but very often there were quarrel at his shop. Sometimes he even used to physically assault other person. He used to have relations with some underground personnel. Once Nipendas went to Chatting village, which is situated at about 223 kilometers from Longding, for delivering some hunting boots. But at Chatting village, he was abducted by some underground personnel, and later on he was released after money was given to underground personnel. After his return, Nipendas used to blame me that I had made him suffer through underground personnel, which is not correct. There were frequent demand of money by some underground personnel. One after Sharma was also abducted by some underground personnel during that time in demand of money. I was also demanded rupees 50,000 by unknown underground personnel. Accordingly, I had given rupees 30,000 cash and one mobile handset. I was having good relation with Nipendas since my shop was situated on the downside of market and the shop of Nipendas was situated at the market. I was having downfall of my business. After a few days, I found one shop at the market nearby the main road and was furnishing the same for shifting my mobile shop. One day, Nipendas came to me and asked me not to open mobile shop there. He rather asked me to open grocery shop or any other showroom at the new shop. I did not agree the proposal of Nipendas. After a few days, Nipendas again came to my shop and proposed for opening partnership shop with him. I have not accepted his proposal as I was not willing to carry on any partnership business. Thereafter, I have started receiving unknown phone calls and messages threatening me and demanding money on my mobile. I have disclosed the same thing to Nipendas, but Nipendas started to avoid me. Earlier, after closing the shop, Nipendas used to come to my shop, and during that time, Nipendas has not come to my shop for several days. On the particular date of incident, I was at my shop. During that time, accused woman came to my shop for demanding one tempered glass of mobile. My shop is vertical in shape, and I was on the backside of the shop. On demand of tempered glass, I took one tempered glass and came to the front of the shop to show the tempered glass to Kuman. During that time, Kuman has told me that he does not want the tempered glass given by me and went away. During that time, accused Ahan, who was standing there covering his face by some scarf, has thrown acid upon me. I know Ahan Vangsha, as he used to work at the shop of Nipendas, and sometimes he used to bring customers to my shop. and I used to give him commissions. On the time of incident, I recognized Ahan Wangsa from his wearing apparels and body language, even though his face was covered. Immediately after the incident, I called one of my friend over phone and asked for help. I was immediately taken to hospital at Longding and thereafter to the hospital at Dibrugarh for treatment. Since I was severely injured, I stayed for several days at Dibrugarh hospital. On the next day of incident, there was a rally at Longding where Nipendash was in front. He given the statement that if the local people wants to chase away the non-tribal persons from Longding, they should not throw acid, rather they should ask them to leave Longding peacefully. During investigation, the IO of the case inquired me as to whether I suspect Nipendash for commission of the offense. I denied, as I was having good relationship with him. There was one CCTV footage during the time of the present incident at traffic point. After about 15-16 days of the incident, one unknown person has called me over phone. Since I was lying on the bed, my elder brother had received the phone call. The unknown call had threatened over phone and told that the acid was thrown upon me with the intention to kill me. Since I did not succumb to injury, the unknown person had threatened me not to come back to Longding again. Otherwise, I have to face dire consequences. Upon receipt of the threatening call from unknown caller, I have called the IO of the case and given him the phone number of unknown caller and informed the matter to him. After a few days, the IO have informed me that Nipendash is the person who caused acid attack upon me. Accused Ahan, who is well known to me, very often used to come to my shop asking for pocket money. I cannot believe that my friend Nipendash and Ahan also have conspired against me and thrown acid upon me. Since then, I was in the mental shock as well as physical injury. After the incident, I sustained severe acid burn injury over my entire body, including head, neck, face, hand, and chest. The witness has shown the injury mark over the body, which seems severe and scary. I stayed at ICU for several months. There were 3 plastic surgeries done by doctor upon me. The doctor has asked me not to go out and told that there is possibility of infection. Due to the injury, I had sustained financial loss. Now I have sold out the shop as well as my car for meeting up the expenditure of treatment. The shopkeepers of Longding have also contributed some amount for my treatment as I was left penniless during my treatment. Had I not shifted my mobile shop, I might have not suffered. The witness broke down in tears. My brother, who was at shop during the time of incident, has also sustained acid burn injury on his leg. Till date, my left eardrum is blocked, and my brother is also not able to walk properly, and we have to go for further treatment. Nipendash was very much powerful in Longding area. He even had good terms with army personnel. During the time of marriage of Nipendash, the army officer had also attended his marriage. Nipendash used to call himself boss of Longding. One day, I, along with Langfo Langpan, was standing nearby the road. During that time, Nipendash arrived there. Langfo called Nipendash as Don of Longding and asked him to bring matchstick. After a few days, I received one phone call from army asking me to appear at army camp. On my arrival at army camp, the army officer has started to assault me without any reason and giving false allegation. During that time, Langfo was also brought by army and he was also physically assaulted by army personnel. Now I cannot prove that such act of physical assault upon us was done on the insistence of Nipen, but I apprehended that incident took place due to the existence of Nipendash. A threatening before the incident and after the incident was from the same mobile number. Nipendash also used to sell TV SIM card, etc. at his shop. Once Nipendash was apprehended at Dimapur with black SIM card, a CCTV at the shop of Nipendash used to cover the entire market, but on the particular date of incident, the CCTV of Nipendash was closed and there was no footage. Exhibit number 12, 13 numbers of photographs showing my injury and my brother's. Cross-examination. Since about 2010-2011, I know Nipendash. Before the incident, there was no quarrel between me and the Nipendash, and he has not given me any intimidation. I have seen one UG person, underground person, who came to the president of Nipendash, and Nipendash dropped at his village by his motorcycle. Nipendash did not threaten me to do partnership business with him. I do not remember the phone number from which I have received threatening call. but I had given the number to the IO and it was the same number. Police has taken my statement over phone. During the time of throwing acid, I could not identify the miscreants as acid fall on my face. But later on, when CCTV footage was shown to me, I could recognize the accused Ahan as to be the miscreant. The incident took place on Sunday and it was evening time. It is a fact that during the time of incident, I did not know who threw acid upon me and from the police only I came to know. It is not a fact that I am falsely implicating accused Nipendas and other two accused persons. It is not a fact that I have given different statement before the police and this court. It is not a fact that due to business rivalry, I am giving false evidence against Nipendas. I have never stated before police that underground personnel took money from me. Cross-examination further. Immediately before the incident, my brother was in front and playing on his mobile and I was behind. Since temper glass was kept towards the backside of the shop, I took out the temper glass and came to the front to give the same as demanded. It is not a fact that I had told before the police that my brother was dealing with customers. Before the incident, the accused came once covering his face and from his body language, I could make out that it is Ahang Wangsa. I did not state before police that Ahang was the miscreant. After my treatment, the CCTV footage was shown to me and I recognized that it was Ahang Wangsa who threw acid upon me. W9 is the brother. I know the accused Nipendas standing on the dock. He has a mobile shop at Longding Market. My brother Anwaruddin has also one mobile shop. My brother was shifting his mobile shop to the main market. Accused Nipen once told me to ask my brother for not to open mobile shop at the market. He rather proposed for doing joint business with him. He even told me that otherwise there may be some problem in future. I informed the matter to my brother, but he did not take the statement of accused seriously. On the date of incident, me and my brother Anwaruddin was at our mobile shop. It was evening and time for closing the shop. I was sitting towards the front side and playing on my mobile. My brother was behind me. During that time, one customer came to the shop and asked for tempered glass. I do not know what happened thereafter, but all of a sudden, some water-like substance fallen on us. Initially, I thought that somebody might be making fun by throwing water upon us, but within no time, I have started to feel the burning sensation on the places where the liquid substance touched in my body. There was smoke everywhere, and even I was not being able to see my brother after the incident. I sustained acid burn injury over both of my legs, including back. Cross-examination. Nipendas had good relation with my brother. I cannot say that Nipendas threatened my brother through me for not opening mobile shop. It is a fact that I do not know who has thrown acid upon us. Page 28 is the PW10 is the doctoral lawsuit. I have read out.
You already read it.
Yes, already read it. Page 30 is the court witness magistrate. He has proved this confession and 164 statement.
Yes.
Huh? Are you police ever? Oh. Are you actually going? PW7, are you maybe?
Where is the confessional statement of?
Page 124, lawsuit. I was referring to page 126.
So there is a typing mistake here, at page 125. The first sentence of the last paragraph. Went to the house of Anwar. Was it Anwar or Nipen?
Nipen. Totally. That's funny.
Yes. Yes,
Page 126, Lordship.
yes.
This is the mandatory requirement to prescribe memorandum. I have examined the Aham Ansha that he is not bound to make a confession, that if he does so any confession, it may be used as evidence against him, and I believe that his confession was voluntarily made. It was taken in my presence and hearing and was read over to the person making it and admitted by him to be correct, and it contains full and true account of the statements made by him. Now, section 164(4) is already there. What has to be written? There cannot be any deviation or omission. Section says, Lordship.
So it is a inculpatory statement where he implicates the co-accused also.
Yes,
Section 10
yes.
Evidence Act will come in, 1030.
So 120B is there, this 30. But whether it can be first, whether this confession is admissible.
Why not?
Because
Why not?
my humble submission is that the learned magistrate did not fulfill the mandatory provision of explaining. Explaining, because it has come as a document.
Explaining what?
Explaining the what will happen if he confess.
No, it is there.
No, it is examined. And it is a vital mistake. We cannot take it as an explained as. We cannot presume it is an explained.
No, the magistrate has said that it could be used in evidence.
It is a document.
I have read it somewhere. In her testimony, she has said so. CW1, hasn't she said?
It is evidence, maybe Lordship, but this is a
The
document.
magistrate is CW1, is it?
CW1, Lordship. CW1 is it?
He said it could be used as evidence against him in trial.
Yes.
That she said in her deposition.
It cannot be improved because it's a document. It is a.
No. If it is not written in the document, it doesn't mean it was not said.
That is what my submission, Lordship. It is a mandatory requirement of section
Document
164.
challenge the document. We are not on the correctness of the document. We are on the question whether there is evidence to show that the accused was informed of the consequences.
Yes.
That evidence is coming from CW1.
My humble submission is it cannot be come on oral evidence because
Is there
confession.
any law?
Yes, Lordship, it is a mandatory requirement because 164(4), it is quote unquote, in 164(4), quote unquote, it has been given what has to be written. Clearly written, I have explained to such and such that he is not bound to make a confession, and that if he does so, any confession he may be used as evidence against him. And I believe that this confession was voluntarily made. It was taken in my presence and hearing, and was read over to the person making it and admitted by him to be correct. And it contains a full and true account of the statement made by him. It is given in the section itself, quote unquote, that every confessional statement should be recorded in such manner.
Which judgment you are referring to?
Confession, Lordship.
Karwan Singh, Ratan Singh.
Yes, Lordship. Will be easier if we first page. First lordship, page 23, 2001, 4 SCC 9, Dhananjay Reddy.
Page 23.
Page 23,
Hmm.
paragraph 20, 21. The function of the magistrate in recording confession under section 164 of the code is a very solemn act which is obliged to perform, which he is obliged to perform by taking due care to ensure that all the requirements of section 164 are fully satisfied. The magistrate recording such statement should not adopt a casual approach as appears to have been shown by tumbling up PW50 in this case. Besides ensuring that the confessional statement being made before him is voluntary and without pressure, the magistrate must record the confession in the manner laid down by the section. Omission to comply with the mandatory provision, one of such being as incorporating subsection 4 of section 164, is likely to render the confessional statement inadmissible. The words shall be signed by the person making the confession are mandatory in nature, and the magistrate recording the confession has no option. Mere failure to get the signature of the person making the confession may not be very material if the making of such statement is not disputed by the accused, but in cases where the making of the statement itself is in controversy, the omission to get the signature is fatal. Paragraph 21. Dealing with
Just 1 minute. Where is the 313 statement of the accused?
yes, Lordship, page. Aham also, it's that's from 20. Huh? 50.
Page 50.
Page 50.
All right. It'll take some time, the matter. How long will you take around?
I will deliver some decision on 164 statement also.
Mhm. And then, Mr. Chaudhary, how much time will you require?
Take much time because he has already read.
And you will need some time. All right. So what we'll do is we have to rise now because 1 o'clock there is some assignment. We'll again sit at 2. SKN Mohammed, Learned Counsel for the appellant, submits that he is yet to receive the paper book prepared by the registry in connection with this appeal, and therefore not in a position to conduct the final hearing of the matter today. First up, Ms. S. Chahan, Learned APP Assam, submits that she has received copy of the paper book. First up, in view of the above, we direct the registry to furnish paper book. We direct the registry to verify and furnish paper book to Mr. S.K. Noor Mohammed, Learned Counsel of the appellant. Let this appeal be listed again in the month of January 2023 for hearing. Yes.
Item 1 is
Yes.
Lordship, I have submitted this Oshini Kolida case also.
Mhm.
I have relied upon 4 decisions from there, Lordship.
Mm.
4.
And Mr. Chaudhary, you were there in this case.
It was for the co-accused.
Any appeal preferred against this judgment, obviously.
One of the. Yes.
It
With
is-
a public servant. Other they have already.
And the main accused has not preferred any.
Accused, I don't know. Co-accused.
No, the reason we are asking is some views have been taken in this matter, which is a little, could be a little different from the conventional approach. So is there any, what has happened to the SLP? All right. Yes.
I was submitting on confession, Lordship, recording of confession, mandatory provision,
Yes.
164. First decision. One, Sarwan Singh, I have relied upon, Lordship. The same page 13, Lordship. May I please refer to page 10, page 18, paragraph 10. Most particularly, page 19, Lordship. Page 19, 18 line from the top. Eighteenth line. Lord. It is hardly necessary to emphasize that the act of recording a confession. It is the same.
You're
thing-
reading from page,
Page 19, Lordship. Page 19, Sarwan Singh.
Yes.
It is from the top 18th line,
Oh, you are reading servants' judgment.
Lordship. Compilation. Citation to 1957. Yes, AIR 1957, SC 67. 637.
Yes, paragraph 19. Page
Paragraph
19.
10, Lordship. Paragraph 10,
Paragraph 10, page 19.
page 19.
Yes.
It is a long paragraph. At
Hmm.
page 19, 18th line. From the it is hardly necessary to emphasize.
Yes.
It is the same statement I was referring earlier to next judgment. It is hardly necessary to emphasize the act of recording confessions under section 164 of the Code of Criminal Procedure is a very solemn act, and in discharging his duties under the said section, the magistrate must take care to see that the requirements of subsection 3 of section 164 are fully satisfied. It would of course be necessary in every case to put the questions prescribed by the High Court circulars, but the questions intended to be put under subsection 3 of section 164 should not be allowed to become a matter of mere mechanical inquiry. No element of casualness should be allowed to creep in, and the magistrate should be fully satisfied that the confessional statement which the accused wants to make is in fact in a substance voluntary. Then incidentally, we may invite the attention of the High Court of Punjab to the fact that the circulars issued by the High Court of Punjab in the matter of the procedure to be followed and questions to be put to the accused by the magistrates. Recording confessions under section 164 may be revised and suitable amendments and additions made in the said circulars in the light of similar circulars issued by the High Courts of Uttar Pradesh, Bombay and Madras. The whole object of putting questions to an accused person who offers to confess is to obtain an assurance of the fact that the confession is not caused by any inducement, threat or promise having reference to the charge against the accused person as mentioned in section 24 of the Indian Evidence Act. There can be no doubt that when an accused is produced before the magistrate by the investigating officer, it is of the utmost importance that the mind of the accused person should be completely freed from any possible influence of the police, and the effective way of securing such freedom from fear to the accused person is to send him to jail custody and give him adequate time to consider whether he should make a confession at all. It would naturally be difficult to lay down any hard and fast rule as to the time which should be allowed to an accused person in any given case. However, speaking generally, it would, we think, be reasonable to insist upon giving an accused person at least 24 hours to decide whether or not he should make a confession. Where there may be reason to suspect that the accused has been persuaded or coerced to make a confession, even longer period may have to be given to him before his statement is recorded. In our opinion, in the circumstances of this case, it is impossible to accept the view that enough time was given to the accused to think of the matter. Next judgment, Lordship.
Yes.
This is also on requirement. There is page 23. I was referring to before recess. It was paragraph 20. 20 I already read out.
Hmm.
Paragraph 21.
You want to rely on which paragraph?
Paragraph 21. 2021.
Hmm.
Page 32. Judgment starts from page 23.
Yes.
2001-4 9. Dhananjay Reddy versus State of Karnataka.
Yes.
Paragraph 20. The function of the magistrate in recording confession under section 164 of the code is a very solemn act, which he is obliged to perform by taking due care to ensure that all the requirements of section 164 are fully satisfied. The magistrate recording such a statement should not adopt a casual approach, as appears to have been shown by Shambhu Lingappa, PW 50 in this case. Besides ensuring that the confessional statement being made before him is voluntarily and without pressure, the magistrate must record the confession in the manner laid down by the section. Omission to comply with the mandatory provision, one of such being as incorporated in subsection 4 of section 164, is likely to render the confessional statement inadmissible. The words shall be signed by the person making the confession are mandatory in nature, and the magistrate recording the confession has no option. Mere failure to get the signature of the person making the confession may not be very material if the making of such statement is not disputed by the accused, but in cases where the making of a statement itself is in controversy, the omission to get the signature is fatal. Paragraph 21. Dealing with a case where the magistrate was found to have not complied with the mandate of subsection 2 of section 164 of the code, this court in Kehar Singh versus State of Delhi Administration held that the compliance with the subsection being mandatory and imperative, its non-compliance renders the confession inadmissible in evidence. Such a defect cannot be cured under the section 463 CRPC. We have no hesitation to hold that compliance with subsection 4 of section 164 of the code is mandatory, and its non-compliance renders the confession not admissible or reliable. It is a settled position of law that if a part of confession is excluded under any provision of law, the entire confessional statement in all its parts, including the admission of minor incriminating facts, must be excluded unless proof of it is permitted by some other section, such as section 27 of Evidence Act. Therefore, I submit, Lordship, in our case, this that I have explained as required by section 164(4). This quote unquote, it has been written in the statute, what is to be written by the magistrate while recording system. So this mandatory, the omission to follow this mandatory provision make this confessional statement inadmissible. First instance.
The conviction is based only on confessional statement.
Confessional statement and corroboration has been sought with the 164 statement of PW6 and FIR, CDR and PW8's CCTV evidence that on seeing CCTV, he could identify after after he returned from the treatment that Ahon Wangsa threw the acid. And CCTV footage is not before the court. It was not seized. Even Lordship in this case, IO has been examined before PW8 and 9 was examined.
They don't know how to.
I don't know, but the CCTV was not there. We could have put
State of
question.
Arunachal police and judicial officer, they don't know how to conduct. They are going to do it like this only.
There is no CCTV footage at all.
That is why all cases mostly it results in acquittal. Mr. Chaudhary knows it. And they are not going to change. They are not concerned. Yes, you continue.
Next, Lordship, this is on restricted confession. It is Ravindra Kumar Pal case, 2011-2 SCC 492. What are the requirements? It is
Retroactive confession can be relied upon if there is corroborating material.
yes.
That's the law. Ravindra Kumar Pal. Is it not?
yes, yes,
Retracted confession can also be the basis of conviction,
corroboration.
provided there is corroborating material, which establishes that it was truthful and voluntary.
Yes.
Anything else?
Yeah, that is another thing. The provision of section 164 must be complied not only for but in essence. 164, it is again goes to requirement, mandatory requirement. At paragraph 164 of the husband, there are 12 criteria which should be fulfilled. In that case, it was referred, discussed, Lordship. Absolutely. Paragraph 64. Paragraph 64 is at page 82 in my compilation.
Page 64.
64. See 82. Page 82, paragraph 64 of this Darashing case, Ravindra Pal case.
Yes.
The following principles emerge with regard to section 164 CRPC. The provision of section 164 CRPC must be complied with not only form but in essence. Two, before proceeding to record the confessional statement, a searching and inquiry must be made from the accused as to the custody from which he was produced and the treatment he had been receiving in such custody in order to ensure that there is no scope for doubt of any sort of extraneous influence proceeding from a source interested in prosecution. A magistrate should ask the accused as to why he wants to make a statement which surely shall go against his interest in the trial. A maker should be granted sufficient time for reflection. He should be assumed protection from any assured of protection from any sort of apprehended torture or pressure from the police in case he declines to make a confessional statement. A judicial confession not given voluntarily is unreliable. More so when such a confession is retracted, the confession cannot be based on such retracted judicial confession. Non-compliance with section 164 CRPC goes to the root of the magistrate's jurisdiction to record the confession and render the confession unworthy of credence. During the time of reflection, the accused should be completely out of police influence. The judicial officer who is entrusted with the duty of recording confession must apply his judicial mind to ascertain and satisfy his conscience that the statement of the accused is not on account of any extraneous influence on him. At the time of recording of statement of the accused, no police or police official shall be present in the open court. Confession of co-accused is a weak type of evidence. Usually, the court requires some corroboration from the confessional statement before convicting the accused person on such a statement. So, non-compliance has affected this confession at the very root, inadmissible. Now, evidence regarding evidentiary value, its double test and other next division lordship page 95 lordship 2007-12 SCC 230 Oloknath Datta.
Yes.
First, regarding there are three aspects of in the judgment, what I like to refer. First is constitutional postulates and retracted confession, then legislative paradigm on retracted confession and an evidentiary value of retracted confession. Paragraph at page 132, paragraph 95 onwards, I am not reading. It is about these constitutional postulates and retracted confession. Page 132.
You're referring to page 132.
Page 132. Paragraph 95. Article 23 of the Constitution of India provides that no person accused of any offense shall be compelled to be a witness against himself. The right to remain silent is an extension of the rule of civil liberty enjoined by our Constitution. 96. Considering the guarantee under Article 23 and also humanizing standards under Article 21, we need to tread cautiously while construing retracted confession. Although such caution is subject to some exception, such as per se evidence of the motivating factors of retraction or retraction based on extraneous circumstances. So, decisions, Nandini Shatri, etc. Now, paragraph 99 is a conclusion. After this 97, 98. To withdraw from what has been said previously needs to be interpreted in the vein of right to remain silent as an extension of civil liberty. The quality of merit of confession in no uncertain terms is in voluntary narration by the accused. At the same time, we are equally in know of the troubled times the judiciary is plagued with. The issue of evidentiary standards is a very delicate one and has a great bearing on the outcome of cases. But be that as it may, basic tenets of criminal law cannot be lost sight of. In similar vein, the law on reiterated confession must be judged in the context of each case. Next, back to paragraph, refer paragraph 104. 104, 105, 106.
Yes, please read which paragraphs you want.
Section 104, Lordship. Section 164, however, makes the confession before a magistrate admissible in evidence. The matter in which such confession is to be recorded by the magistrate is provided under Section 164 of the Code of Criminal Procedure. The said provision, inter alia, seeks to protect an accused from making a confession, which may include a confession before a magistrate, till as may be under influence prior to promise from a person in authority. It takes into its embrace the right of an accused flowing from Article 23 of Constitution of India, as also Article 21 thereof. Although Section 164 provides for safeguards, the same cannot be said to be exhaustive in nature. The magistrate putting the questions to an accused brought before him from police custody should sometime, in our opinion, be more intrusive than that is required in law. 105. In a case where confession is made in the presence of a magistrate conforming the requirements of Section 164, if it is retracted at a later stage, the court, in our opinion, should probe deeper into the matter. Despite procedural safeguards contained in the said provision, in our opinion, the learned magistrate should satisfy himself whether the confession was voluntary in nature. It has to be appreciated that there can be times where, despite such procedural safeguards, confessions are made for unknown reasons and in fact made out of fear of police. 106. Judicial confession must be recorded in strict compliance with the provision of Section 164 of the Code of Criminal Procedure. While doing so, the court shall not go by the black letter of law as contained in the aforementioned provision, but must make further probe so as to satisfy itself that the confession is truly voluntarily and had not been by reason of any inducement, threat, or torture. Then evidentiary value of detective officer starts from paragraph 110, Lordship. May I please take a Lordship directly to the paragraph 116? What is your paragraph 116?
Yes.
Page 137. Whatever be the terminology used, one rule is almost certain that no judgment of conviction shall be passed on an uncorroborated retracted confession. The court shall consider the materials on record objectively in regard to the reason of retraction. It must arrive at a finding that the confession was truthful and voluntary. Merit of the confession being the voluntariness and truthfulness, the same in no circumstance could be compromised. We are not oblivious of some of the decisions of this court which proceeded on the basis that the conviction of an accused on the basis of a retracted confession is permissible, but only if it is found that retraction made by the accused was wholly on a false premise. 117. There cannot, however, be any doubt or dispute that although retracted confession is admissible, the same should be looked at with some amount of suspicion, a stronger suspicion than that which is attached to the confession of an approver who leads evidence in the court.
Yes.
Then Shankaria case, it was also decided, dealt with by lordship in the Australian the decision. In the paragraph 23, the double test, truthfulness and voluntariness. In our case, the confessional statement itself is not admissible. So it does not have any evidentiary value. My humble submission. Next point. Lordship, whether the corroboration taken from the 164 statement, whether that 164 was available to the prosecution or to the learned trial court to rely upon. Because PW6 was not declared hostile. 164 statement has not been confronted with him. It was only exhibited by IO, and then the magistrate came and stated that I have recorded his statement.
So why should the confessional statement be put to PW6?
For corroboration.
No, that's what why he should corroborate.
No, court has taken corroboration of PW6 to rely upon my retracted confession.
No, Mr. Purkasto, see, either you explain it to us or agree. Confessional statement, the accused person, if it is read on the face of it, he has described what has happened, how the co-accused has asked him first to kill that person with a dao. He said it's not possible. Then he came with a jug of acid, etc., etc. He threw it. PW6 doesn't know all these things.
Yes.
PW6 is relevant only because he claims that he could identify the accused, Wangso. What is his name? Wangso.
Ahal Wangso.
Ahal Wangso. To that extent.
Yes.
So PW6 cannot corroborate the version of the accused in the retracted confession.
Yes.
So where is the question of
But
corroboration?
then it goes, and what trial court did, it is wrong. Trial court took, it is treated this 164 statement is a substantive piece of evidence.
No, that's not correct.
That is kind of, so there are few judgments.
It's not substantive piece of evidence,
Yes.
but we'll have to see whether, despite retraction, whether these statements made by the accused can be treated as truthful and voluntary, free from any coercion, influence, and whether it fits into the overall story of the prosecution. And to that extent, whether there is corroboration of his version.
Whether there is other
That we'll
corroboration.
see.
Yes.
That we'll see. If he says something and then prosecution leads evidence which projects a different story, then it has to be discarded only on that count. If it fits into the story, then procedural safeguards, to what extent it has been given. If procedural safeguards are mandatory, but if the court from other materials can come to a conclusion that the confessional statement was voluntary, does not suffer from any material defect, and can be relied upon, then it will be a different matter.
Yes.
It is a different matter because there are many cases where in toto 164 may not have been complied with. For example, in case of Ashwini Kalita, here the court has held that although there was some deviation, if I remember correctly, the question was not put to the accused why he wants to make a confession. That question was not put. But only because that question was not put, do you throw out his confessional statement? The court did not agree with that view. So therefore, even in this case, even if that is not there in the written format, that the accused was not informed that it will be used as evidence against him, we will see what impact it has on the testimony of CW1.
Yes.
And how in the cross-examination, what was this evidence challenged or has the defense accepted it? These are factors we'll see. It is not a question of whether this was put to the accused or not. The question is, if it is absent in the form and brought in evidence by CW1, whether it is acceptable. So please bear that in mind.
Yes. Yes.
Bear it in mind.
That
That
is
is
what-
the point here,
Yes.
not, this is not a case where it was not put to the accused. It is a case that it was not mentioned in the form, but the magistrate has adduced evidence saying that it was told to the accused. That is the point here. So no point relying on judgments which says 164 is mandatory, it has to be followed. These judgments do not say in what manner it should be followed.
It is that Lordship, I relied upon a decision that it cannot be curable. There are something, 463 says something is curable. Even if it is not in there.
Hmm.
The decision says that even it is not curable under section 463 CRPC. If it is not curable under 463 CRPC, which give an exemption of the section 91 of Evidence Act.
Hmm.
So this is mandatory. There is no other way to cure it. Even the magistrate deposing in the court saying that I have explained will not suffice. Decision says even 463 does not cure it. Therefore, my humble submission would be that this confession is inadmissible evidence, the first instance, apart from retraction, evidentiary value of the retracted confession.
All right.
And
Yes, please.
if 164 statement goes, if it is not required to rely upon decisions, Lordship, then the order the other corroboration, I need to take the Lordship the judgment again. What are the again other corroborations? Paragraph 51 onwards, page 90.
Citation.
No, citation, no, that is a judgment, Lordship. What's a judgment?
No, it is in the paper book,
Paper book, Lordship.
page 91.
Page 90, Lordship. Paragraph 51 onwards. May I please read? 51. As a matter of prudence, before coming to any finding regarding to the confession made by accused Ahang Wangsa, let us examine the fact to find out as to whether there is any corroboration or other materials and statement of witnesses with the confession made by the accused. FIR discloses that the incident took place on 3/2/2019 on the evening. The same corroborates with the confession of accused. Throwing acid upon victim Anwaruddin and causing grievous injury is also corroborated from the statement of all the prosecution witnesses, including victim and doctor. The fact of making returning call to victim is also corroborated with the statement of victim PW8 as well as PW7, the IO of the case. It is also corroborated that the accused also after making threatening call to the victim using the phone and SIM provided by Nipen Das has destroyed the SIM card, handed over the phone at the shop of Nipen Das as the IO has recovered the said mobile from possession of Nipen Das. The confession that the accused also after throwing acid asked by Nipen Das went to Pongsaw also corroborates as he was apprehended by IO from Pongsaw. In view of total corroboration regarding the minute facts of the present case with the confession made by accused Ahan Wangsa, it is found that the confession is voluntary as well as true narration of the case. During examination of accused Ahan Wangsa as provided under section 313 CRPC, he simply denied that he does not know about the confession. But the fact and circumstances proved in the case are totally corroborated with the confession of accused Ahan Wangsa. As the same is required to be relied on, even though the confession is retracted by the accused. In the present case, FIR reveals that on 3/2/2019 at about 5:43 hours, an unidentified miscreants came to PK mobile shop and thrown acid upon Anwaruddin and fled away. The evidence on record disclosed that the miscreant, while throwing acid upon Anwaruddin, came covering his face with a mask, and after throwing acid by a jug brought by miscreant, he thrown away the jug and ran away from the spot. PW2, 3, 4, 5, and 6 have deposed before the court that they were present at the place of occurrence when the miscreant thrown acid, liquid substance upon Anwaruddin. They have also testified that when sprinkle of liquid substance touched their body on different places, they experienced burning sensation and thereafter they were taken to hospital for medical treatment. But said witnesses could not identify the miscreant, as immediately after throwing acid upon Anwaruddin, the miscreant fled away from the spot. PW7, who is the IO of the present case, has deposed that after arrest, accused Nipendas has disclosed the same name of accused Ahan Wangsa and Puman Wang Now as co-accused who have committed the offense, and accordingly, IO has apprehended Puman Wang Now and Ahan Wangsa. Accused Ahan Wangsa has confessed that he has thrown acid upon Anwaruddin as asked by Nipendas, and accordingly, his confessional statement is recorded by Lanet JMFC Longding. It is further stated by the PW7 that PW6, namely Manai Wangsa, who was present at the place of occurrence, has deposed before the Lanet JMFC Longding that he was present when accused Wangsa came to the PO covering his face and fled away from the place after throwing acid upon Anwaruddin. During cross-examination of PW7, he has affirmed that witness Manai Wangsa has seen accused Ahan Wangsa throwing acid upon the victim. The jug used for throwing acid seized him from the place of occurrence. PW8, Anwaruddin, the victim in the present case, has deposed that when he was at the shop, accused Puman came to his shop and asked for tempered glass, and accordingly he had shown him the same, but Puman told that he does not want the same and went away. During the time, accused Ahan was standing there covering his face by some scarf and thrown acid upon him. He knows Ahan Wangsa as he used to work at the shop of Nipendas, and sometimes he used to bring customer to his shop and he used to give commission. On the time of incident, he recognized Ahan Wangsa from his wearing apparel and body language, even though his face was covered. During his cross-examination, he stated that at the time of throwing acid, he could not identify the miscreant and as acid fell on his face. Later on, when CCTV footage was shown to him, he can recognize accused Ahan Wangsa as to be the miscreant. He has also stated during cross-examination that he do not know who threw an acid upon him. He only knew through police. Before the incident, Ahan once came to his shop covering his face, and from his body language, he can make out that it was Ahan Wangsa. He did not state before the police that Ahan Wangsa was the miscreant. After his treatment, the CCTV footage was shown to him, and he recognizes that it was Ahan Wangsa who has thrown acid upon him. Court witness, next page. The court witness one, Srimati E.P. Kapoor, who has recorded confessional statement of accused Ahan Wangsa and statement of witness of Manai Wangsa as provided under section 164(5). CRPC has specifically deposed that accused Ahan Wangsa has confessed before her that on 3/2/2019 he has thrown the acid liquid substance on the face of Anwaruddin as asked by Nipendas and ran away. PW1 further deposed PW6. Sri Manai Wangsa has deposed before her that he had seen Ahan Wangsa coming to the place of occurrence holding a jug on his hand and covering his face. Manai has identified from Ahan from his cut mark on the cheek and wearing apparels with physical appearance. Ahan went to the shop of the Anwaruddin and thrown the liquid substance in the jug on the face of Anwaruddin and ran away. He has exhibited the confessional statement accused Ahan Wangsa exhibit 10 and statement of witness Manai Wangsa as exhibit 9, along with her signature therein. During her cross-examination, the above material fact could not be rebutted, and there is no contradiction raising any doubt upon the materials on record, as everything is corroborated from the fact of the case. I have physically seen a cut mark from the cheek of accused Ahan Wangsa while he is produced during the entire hearing of the case, which corroborates the statement of Manai Wangsa that he identified accused Ahan from his wearing apparels and cut mark on the cheek above the face cover. Repeatedly, Lordship, Ahan statement of Ahan Wangsa, Manai Wangsa is coming. It has been repeatedly taken into consideration. CCTV footage was not released. PW8 also stated that he did not say to police that he identified Ahan Wangsa as miscreant. So this evidence has been taken into consideration for corroboration. Apart from that, mobile phone calls, that it is also corroborated accused Ahan Wangsa after making threatening call to the victim using the phone SIM provided by Nipendas has destroyed the SIM card. and handed over the phone at shop Nipon Das. Now, CDR is also exhibited. Exhibited to IO PW7. No, page. And then page 119, Lordship. The secondary evidence, Lordship. I am not on 65B. 65B certificate is, it is not no more required. If it is proved as per law, it has been proved through IO. There is no certifying officer, but from the CDR, from which service provider? We cannot understand from which service provider it issued. If there is a phone call, it is to be understood from the CDR. CDR has to be proved according to law. Here, my humble submission that it has not been proved as per law, because the apex court in the case of that Navjot Sadhu Afsan Guru case, 2005-11, I have relied upon a volume book. Perhaps there is a
So
bundle
what
of-
is the point you are saying? The CDR?
CDR
Hmm.
has not been proved as per law. Only IO has exhibited it. Now, in
Alright.
this case, it has been stated how a CDR has to be proved. Even though there is no certificate under 65B Evidence Act, there is a procedure, because nodal officer or any officer of certificate
What does the IO say on the CDR? Let's see his testimony once.
PW7,
Page number
PW7, page 17,
17.
17.
Please take us to the specific part of CDR.
Page 18, Lordship.
Yes.
First paragraph. During investigation, it was revealed that on 13 to 2019 at around 24 hours, victim Anwaruddin received a threatening call from unknown person from number 7640860421 to face dire consequences if he comes to Longding again. We have suspicion over one Nipenda Skala. Accordingly, searched his shop and recovered one idle mobile phone, and had noted that EI number of the phone, and also seized other SIM cards of different service provider, which were being sold by Nipendash in market without having any valid document. I have obtained the CDR of the phone with IMI number from which threatening call was made to the victim. On examination of CDR and IMI number, it reveals that the mobile which is recovered from the possession of the accused Nipendash was used for making threatening call to the victim. I have arrested accused Nipenda Skala, alias Skala, who has admitted the guilt of the and disclosed the name of the accused, namely Ahang and Kuman, who have committed the offense. One Manay Wangsha, who accompanied the accused persons on the fateful day, was forwarded for recording of statement under section 164 of CRPC. The same is receipt after being recorded by JMFC. So this is his evidence regarding CDR. He even did not propose from whom this CDR was collected.
And what is there in his cross-examination?
Page 19, Lordship. First, cross-examination for accused Nipendash. The threatening phone call was made from 7640864041 having IMEI number. The person is unknown. As per investigation, accused Aham Wangsha has thrown acid upon victim. Two of the accused persons were present at PO and another was looking from his shop. Witness Manay Wangsha has disclosed before magistrate in his statement in his 165 that he seen accused Aham Wangsha throwing acid upon the victim. The jug used for throwing acid was already touched by many other persons before seizure. Hence, I have not forwarded the same for fingerprint examination. Aham and Manay Wangsha has disclosed that accused Nipendash was watching from his shop, but there is no other independent witnesses who have seen Nipendash at the time of occurrence. Nipendash used to run a mobile shop at Longding Market. Nipendash had not disclosed the exact vendor, but he told the told he procured the same from Dimapur. I do not know whether the SIM cards are issued to other persons by the accused Nipendas. Regarding CDR, there is no other. Oh.
So on the CDR, there is no question. There is no cross-examination of the IO.
But they have not proved it. They failed to prove it.
No, let us assume that they have failed to prove it. But at least his oral evidence is there that from the CDR he has come to know that this is what has happened. That part has not been challenged.
And then Lordship, from CDR, page
No,
119.
what is understand the question? Let us take it that the CDR was not properly exhibited. It is not proved. Let's take it. Let us accept it. But the IO has made oral deposition before the court saying that from whatever materials he's come to know that this call was made by so-and-so to so-and-so. That is an incriminating piece of material, right?
Yes.
But there is no cross-examination of the IO on that point. That's what we are asking you.
Yes, sir.
So that is accepted by the defense, that the IO has actually found out that the call was made from this number to that number, which was, the number was held by so-and-so. And this incriminating piece of evidence has gone on record without being challenged.
That is on the basis of CDR is a document. Again, from the CDR, Lordship will not understand.
You have understood it, but
Lordship.
if you don't deal with it, we will deal with it in our judgment. That we are making it very clear. You cannot duck that question. You have understood
I have
what we
understood
said.
it. I have understood the
Forget
question.
the CDR. There is oral evidence. The IO said that I have found this.
That is
Supposing there was no CDR,
that is what I
you would have said that from our inquiry, I have found that he has made a call to so-and-so, and in this call, this conversation has happened. And there is no challenge to that evidence. Then will the court not be obliged to take note of that evidence?
The person is unknown, Lordship. In his cross-examination, he says the person is unknown. First line, the threatening phone call was made from such and such, the person is unknown. And basis,
No, he said one thing. See, Mr. Bukasta,
in chief he
the
says,
important questions.
in chief he says, Lordship, in chief he
No,
says,
you come to page 18.
yes, 18.
On examination of CDR and IMEI number, in the middle, first paragraph middle, it reveals that the mobile which is recovered from possession of accused Nipen Das was used for making threatening calls to the victim. That part is there.
Yes, sir.
So in his cross-examination, that statement goes unrebutted. That's what we are asking you.
Regarding CR, Lordship, it is. Because it is.
Oh, he said that mobile seized from Nipen Das was used to make phone call to the victim to threaten him.
Yes,
CDR, FDR, forget it.
yes.
That testimony of the IO has remained unrebutted. Do you agree with it or not?
Yes, unrebutted. How it is recovered, Mr. Chaudhary will argue on that.
That is
How it
another
is recovered, whether seizure is correct or not, Lordship. I am not going to that because it comes from there. Recovery from the shop of the Nipendas.
Acha, okay.
Recovery from the shop of the Nipendas, which is recovered from the possession of accused Nipendas, was used for making threatening call to the victim.
All right. Yes, please proceed.
What I
Give it tomorrow again, part hearts. Yes,
what I
we'll
beg to add, Lordship,
continue
also.
tomorrow again, part
Yes.
heart matter. Because another
Lordship.
10 minutes only left. Not now, we'll continue till 3. Yes, yes, please continue.
Because this everything has to be understood from the CDR. I'm not on proof now.
No, all right,
Even we
we
read-
will not repeat it, Mr.
If we read it,
Mr.
Lordship,
Pukasto, you are saying since the CDR was not proved. Therefore, the statement of the IO that he from CDR he came to know this, even if it is unchallenged, will not be an admissible piece of evidence. That is your argument?
No, it is, I have left this on, Lordship. I am saying, Lordship, he has understood from the CDR. Even if we read CDR, we will not understood who has made call to whom.
You have not said that his assertion that the call was made from his number, this number system, is false. You are not saying that. You are saying he is correct. If you do not challenge an assertion made by a witness, that means you accept it to be correct. Is not it? Is not that the position under the law, Mr. Pukastu? That's what we are asking you.
If there is no denial, it will affect.
Huh?
If there is no denial, it will affect. But again, it goes to recovery. Recovery part is there because specific statement of the IO that there is the same number of this SIM card or phone, IMEI number of the phone, which was recovered from the possession of Nipen Das.
Correct.
That part has to be also examined. Whether it was recovered from the possession of Nipen Das.
No, unless you challenge it, why should the court go into that? Why should the court go behind a statement which is not challenged? That's the how law operates. You see, it is technical for accused as well as for prosecution, both. As the way the accused gets benefit of technical lapses, the accused will also have to face the music for technical lapses. That's how criminal trials are. A particular point not challenged during cross will have to be treated as accepted and admitted. That's the law. If you deny and dispute that, come back to us tomorrow with judgments.
It is.
Otherwise, there are decisions.
It does not connect me. It does not connect me.
That is why I said, Ashwini Kalita, read this judgment tonight. You will find answer to all these things here. And these legal pronouncements are based on earlier decisions of the Supreme Court. You see, every case has its peculiar facts and circumstances. And it is while the accused is entitled to acquittal if the charge is not proved, correct. But it is hardly you have a case where things are perfect. So there are technical grounds on which the defense will urge. There are technical grounds which will go against the defense also, equally. So if you have missed out on something, you have missed out. That will have its consequences. It can't be that technical lapses of prosecution, give it to me. My lapses, forget it. That can't be the case.
To connect this particular statement, Lordship, to me, again, confessional statement has to be taken into consideration. And if my submission is, as I have submitted earlier, confession statement goes away, I cannot be connected with this particular statement. It is recovered from Nipen Das.
All right. Proceed. You can proceed. We have some more time. A single line.
Then page 1. Then again, there will be repetition, Lordship, because as I have read out from page paragraph 51 to 57, time and again, this is PW6, the 164 statement on PW6 has been considered. Along with my corroboration, it has been considered. So to negate that, I have already Lordship has said that it can be, it is not necessary on 164 because it is not a substantive piece of evidence.
That's right.
It is not required. Now, again, whether Lordship case, in this case, some photographs have been proved through this PW8. Subsequently, these are not relied upon. It has been exhibited. And it takes morality, of course, if anyone sees this photograph.
Hmm.
So learned trial court also perhaps gave a moral conviction. And to this, he bring this all this corroboration, which was CC footage was not there, CDR was not proved. PW6 could not have been relied upon by 165 statement, and my retraction could not have been considered. Now, I have relied upon two decisions, Lordship, regarding this. Lordship takes my compilation,
Hmm.
paragraph, page 231.
So it'll take some time going through the decision.
Lordship.
Acha, Mr. Chaudhary, what has happened to the CCTV footage?
But the CCTV footage is not available, but it was not disputed by him. What my learned friend has argued, under section 145 Evidence Act, my lord, he should be, my lord, all the denied when he, my lord, cross-examined the witness. Nothing
No,
has.
no, those are arguments on law.
Yes,
We'll
sir.
do it, you'll do it, you'll
Yes,
get
sir.
your chance. We are asking you today, what has happened to the CCTV footage?
I have to go to the case diary one that is not available.
Can you please go through it and who is the IO? We'll call him to come here with the CCTV footage. What do these people think? They will carry out investigation in whichever way they want. Where is the CCTV footage? We want to see that.
To see the case diary one.
You see it and you ask whoever you want to ask. Tomorrow we'll continue and if necessary, we'll call the IO to come here to remain present and assist the court
Yes, sir.
in the manner in which conducted. Where is the CCTV footage? If it is destroyed, then under whose authority it was destroyed?
Yes, sir.
If it is still there, then it should be brought. We'll see.
It was not seized, Lordship.
Huh?
CCTV footage was not seized. Not even IO also did not depose about CCTV footage. It is the PW8 brought it in his state deposition.
So we'll see what has happened.
Can I look the case diary, my lord?
Yes, yes. We'll not take any view which is prejudicial to the accused. Don't worry about it. Not that we'll now fish for evidence and all, no. But if something is there on record, we'll have a look at it. Those days are gone when merely on technical loopholes you can get away. Don't expect that.
Yes.
Take an adjournment and try it somewhere. We have had enough of this business. We have had enough. We will satisfy our conscience on the basis of materials on record. If there is even 1% doubt, it goes in your favor. Otherwise, we'll write a judgment to cover up. We cannot allow the ignorance of the officers here and there to just let criminals of heinous offense just get away. That's not happening. So you also can be on your note that making cosmetic arguments are not going to work out. We'll find out what has happened. Whether it is deliberate, whether it was done due to ignorance, and if so, but yes, there has to be convincing evidence. Any element of doubt, the benefit will go against and it must go in favor of the accused. But just merely some technical loopholes, this question was not asked that you have to test these judgments. If it happens that way, we don't know what will happen. We want to have these views tested. Because the governments are not going to do anything about these things. And this society has a stake in punishing the criminals. We cannot be oblivious about it. We'll see what happens. So, Mr. Chaudhary, go through the CD and see. Heard Mr. SD put question.
That is why in new, my lord, that DD case, my lord, that judgment has passed by the Honorable Apex Court. You have to put the question first, then you give the answer. Sometimes what happens, so just like that, my lord, cricket khelilo, tar sa khalo. Then question asks whether you take tea in Latasil field. That says, I do not take tea in the Latasil field. That was come, my lord. That way, my lord.
There are major let-ups in the way investigation is done, the prosecution is carried out, and even the manner in which judgments are written. All these things require correction. We have to bring these things back on track. So we cannot just go on letting out people on mere technical snag here, technical snag, there. That can't happen. But then, yes, for the third time, we are mentioning that if the charge is not proved by convincing evidence, then it will lead to acquittal. There is no doubt about it. Let us see what happens. Mr. Chaudhary, you can argue tomorrow. But you know the areas where there will be questions, so you can come prepared tomorrow. Yes,
May I please, my lord? Item number 2 and 1 and 2 are going on. I have item number 3.
Hmm.
In that particular case, one I is also pending.
Hmm.
So can we have a date, my lord, in item number 3?
when you want.
My lord, as per the convenience of the court.
No, you choose the date. On the prayer of Mr. B. Dekal and counsel for the appellant applicant, this matter is direct to be posted again on.
My lord, can you have it on 19th?
19th.
Deeply
19th
obliged,
December.
my
Yes, we'll continue tomorrow. 1 and 2, so and so for the state. Arguments remain inconclusive. This is the matter again